I take great issue that Ms. Poteet is even hinting that I did something that is unethical.
And
I
I
want to put
agree
that on
with
the record.
that.
I just want to make sure that I protect and I put that on the record that I take great issue and I take great insult that she is attacking me as my professional courtesy and my ethics. Judge, I
And
understand that you have to fight zealously for your client and attorney's fees, but to stoop so low to accuse me of being unethical, Judge, I'm not going to stand for that.
so, Mr. Juarez, you may proceed then on your motion for attorney's fee.
Can you state your name for the record,
Virginia Leclerc.
Ms. Leclerc? In regards to this cause of action, who did you seek to retain services to help you in this case? What attorney did you hire?
Law Office of Edgar Juarez.
Okay, and when you retained my services, like what was the reason for it? Like what were you trying to accomplish?
What was I trying to accomplish? To
Right.
get the non-custodial parent to make some type of child support payments towards the arrears that we had.
Okay, and do you know what the court ultimately decided? What were the final arrears that they confirmed? Do you remember what the amount was?
From the $60,000 balance, we had to collect I think it was 2 payments for $800, which was October, November, and then one for $8,000 to be paid by December the 16th.
So what was your understanding that he owed?
The full balance?
Right.
60,000 and change.
Okay. In regards to this cause of action, the Attorney General was seeking to confirm the arrearages. You understand that, correct?
Yes.
Okay. Is it your understanding that the court found that he was in arrears in the child support in the amount of $35,229.27?
I'm gonna have to object. This line of questioning is irrelevant as to proving up attorney's fees. This has already been litigated.
Judge,
Correct. And Mr. Juarez, I believe your motion is strictly for the enforcement. So any work you would have done in enforcement, the confirmation of arrears was filed by the Office of the Attorney General. So objection sustained. Just stick to the legal or the work or the services rendered.
I understand, and I apologize, Judge. I guess I was just making my argument under Family Code 157.167, which says that they shall be, the arrearages that we're talking about is more than $20,000, and that's what I was just trying to make sure that I incorporate some language in regards to that, which triggers why he would be required to pay child support. But I'll continue, Judge.
And that's fine. And I think Ms. Poteet, under the circumstances of the order of confirmation of arrears, I think you can stipulate as to that section in the family code that the arrears are more than 20, correct?
Oh, all right. Not an issue, Judge, and I will proceed.
Okay.
If she's told does stipulate, Judge. All right. And so, Ms. Leclerc, when in regards to the attorney's fees, right, what was your understanding of our agreement in regards to me being retained on the case?
Well, when I met with you, give or take about 6 months ago, I went to your office, did an agreement. I had to pay you a retainer fee. And then as we went, depending the kind of work involved, that's what the price was going to be.
Okay. And what determined how much it was going to be? Was it the amount of work that I did, or what was the agreement that we had said that it was going to be? Like
the work involved, the forms that we had to file, how many times we had to go to court.
So you would agree with me that it was based on the amount of work that was done and not necessarily to a specific outcome, right? You would agree with me on that?
It was, can you repeat the question?
So
It was based on what?
based on the amount of work that I did, right?
Yes.
I never said, look, if I win, you're going to pay me this much, and if I lose, you're going to pay me this much. And that was
No.
never discussed. Okay, so I want to make sure that we're on the same page. Okay, and when did I advise you of that? When did I advise you that was going to be the arrangement that we were going to have?
Well, when we first met, you asked for a retainer fee, and then we went to court once, and then we met afterwards, and then we had to go back again to court, and then we went again, and then we had to follow again. So I believe it was about a month and a half, month ago when we met, and you pretty much made it clear that there was more work involved, that also because of my request. So the fee was possibly going to be going up. So you have to see which forms and how much was the cost involved, and you were going to get back with me, which you did.
And at the end, did I more or less tell you what I thought it was gonna come out to?
At the beginning, yes, you gave me a rough estimate.
Do you remember what that rough estimate was?
It could be between $5,000 and $8,000.
Okay. And okay. Do you know what your bill is right now?
The last bill that I got from you was maybe about 2 weeks ago. I think it was around Christmas.
And then that was with and correct me if I'm wrong, but that was when you saw the invoices that I submitted, right?
I got them through the e-file portal
Okay.
that everybody gets.
Okay. And do you remember what the amount was?
I believe it was about 8,000. I think, yeah, because you were charging me for like text messages and calls and.
Okay. Would you disagree with me that the amount was $8,750? Would you
No, I
disagree?
won't disagree.
Okay. And that was because I was charging you at $350 an hour? Is that correct? Okay. And did you review the invoice?
I did.
Okay. Was there anything there that was stated in the invoice that you do not believe that I did that particular work? Or was there something that you say like, no, that's not true. You didn't do this or you didn't do that? Anything?
Well, no, because I do have records, like especially through the text messages, where the messages that the ones that you listed on the invoice, I have like evidence, if that's what you want to call it, through the text messaging, where yes, you're charging me for those minutes. I do have also confirmation, like when we met at your office for about 2 hours, when I think that was the day that we noticed that there was some errors on that form that was submitted that we had to correct.
Okay. And in reviewing the invoice, did you notice that there were certain entries that I didn't list the time, the rate, or the amount? By any chance, did you notice that?
I would have to pull out the invoice to, let me see.
Is there something that would help you recollect or refresh your memory?
Well, I just pulled out the invoice.
Okay.
What is it that you need me to look at?
And specifically on September 30th, 2025, is there anything in regards to that date? Regarding.
And Mr. Juarez, she is testifying from the bill that was attached to your, just to make sure, that was attached to your motion for attorney's fees. That's what she's reviewing right now as you're questioning her?
That's correct, Judge.
Okay.
Yes.
Thank you.
Okay. So on September 30th, 2025, on that particular case, are there entries or work that I did that I'm not charging you for?
I can see that because they're blank entries, no time, rate, or 9 total.
And so in regards to me receiving an email from the judge regarding the final order, was there a fee that I'm assessing to you?
review email from judge regarding final order, 10-4, no.
Okay.
Prepare and drafted email to judge regarding order, 10-1, no.
Okay. And Judge, I have no further questions of this witness, and I pass the witness.
All right, Ms. Poteet, do you have any questions that you want to ask Ms. Leclerc? Any cross-examination?
Yes, Your Honor.
Okay, you may proceed.
Ms. Leclerc, on what date did you hire Mr. Juarez?
Mm. June the 19th, I believe. Let me see. No, hold on. It's before. 22nd. Thursday, June the 19th at 12:15, I made contact with Mr. Juarez, and we set an appointment for 12:30. And he only had And then I asked if it was an over the phone meeting or in person. And then he's like, in person, you can come by my office. And then I told him that I was gonna get ready if I could go in within an hour. So this was back on Thursday, June the 19th, 2025.
So what you are referencing right now were a series of text messages between you and Mr. Juarez, is that correct?
Some were text, this one, yes.
And then there was a phone call as well?
There's been emails, phone calls, and text messages.
But specifically, I'm referencing to the 19th.
That's what I answered. I said I texted him about the first appointment when I hired him.
Okay. So at the time that you texted him, you hadn't yet hired him, is that correct? You were setting up an appointment to meet.
We set an appointment. I met with him. I agreed with the fee, the cost, and yes, I hired him that same day.
Okay, so he billed you for text messages before he was hired.
No. June, if you notice on the law office on the form, June the 19th meeting, spoke with client Virginia telephonically regarding retaining my service. That's the same day that is on my text message.
I don't need to see your phone. So he charged you for a meeting before he was officially retained by you. That is what you were testifying.
There's some attorneys that they do charge a consultation fee, to my understanding.
Okay. You didn't pay a consultation fee that day, is that correct?
Not separately. It was all together with what I paid him that same day. And I made partial payments. And I'm still making payments towards him.
So you... Okay. I'll move on from the 19th. Did you sign a contract or a fee agreement to hire Mr. Juarez?
Did I sign an agreement? I would have to look back through my paperwork to see if I have an actual document that is signed. I did receive some what's it called? Some receipts of the payments.
No, that's not what I asked. My question was, did you sign a contract for services? That's it.
And my response was I would have to go back to my paperwork because I don't recall if I have an actual agreement. As of now, I can tell you I do have receipts that are signed as partial payments.
Okay. When did you receive your first invoice?
The invoice, the final invoice that I got was the same one that you received that I believe it was submitted December, what was it, December the 16th? No, December the 26th, 23rd, around that time.
So that's the very first time you received an invoice? You saw an invoice from Mr. Juarez?
More like an itemized invoice.
So before December 26th, you hadn't received an invoice detailing fees and the work that was done and how much time was spent on your case by Mr. Juarez?
Yes and no. Verbally, yes, I did receive one because we were in contact in constant communication. I did meet with him several times, meeting more than once or twice in his office so that we could discuss the case. And most of the times, every single time that we would log off from the court, I would call him or I would text him and he would call me back. A couple of times afterwards, I did touch base with him. I did go to his office. That's when we would review like this, Ms. Leclerc, this is where we stand. This is how much you've paid so far. This is the work involved. You do understand there's more fees that might inquire. I did talk to Mr. Juarez. I did tell him that there was several things that I wanted to be done. So then that's when he told me that involves more work, more time. Therefore, your price is going to increase. I did ask him how much. Well,
Your Honor, narrative.
Objection sustained.
Okay, Ms. Leclerc. So based on your testimony, before December 26th, you had not received anything in writing regarding the fees?
Not in
just-
writing.
Okay. Testified earlier that you had a chance to review the invoice. Is that correct?
I did.
Okay. Did you notice that Mr. Juarez actually duplicated a billing entry and billed you twice for the same task on 8/13 and 8/19?
Did I notice it? Possibly not, because I might have overlooked it.
Okay.
Is that the one for the Veronica Hernandez regarding meeting and then the original answer regarding respondent, or which one?
On 8/13,
Because there's several.
on 8/13 for a text message, and on 8/19 for the same text message, you were billed twice.
Okay.
Okay.
It's worded differently, so maybe that's why I didn't understand the terms.
Judge, I'm gonna object to the question. It assumes facts not established, so it assumes that it was a duplicate, and so that hasn't even been established, Judge.
What date was it, Miss Poteet?
Your Honor, on 8/13/25, there is a text message that was billed .1. It's the billing entry says reviewed text from Virginia Leclerc regarding respondent's answer. A little bit
And-
lower, on 8/19/25, there's a text message and the billing entry says reviewed text from Virginia Leclerc regarding respondent's answer and a .1. That is the same billing entry word for word.
Judge, just because it's the same entry doesn't mean that it was the same work. Sometimes clients ask me about an answer one day.
All right,
I
objection
do.
overruled. What you could do, Mr. Juarez, is take her on redirect.
Yeah.
But it does look like a double billing. At this time, what I do have to question, I have a question. Who is Veronica Hernandez?
That is my paralegal, Your Honor.
Okay, got it. Okay, objection overruled. You can repeat the question, Ms. Poteet.
Even though you had already answered Ms. Leclerc, but I just want to clarify, on 8/13, the text message billing entry that we just went over is the same as 8/19, the text message with the same billing entry. That's correct?
It's the same wording, but I do have evidence on my text
Objection
message that
answered.
at 8/13.
Asked and answered, Your Honor.
Objection sustained.
Ms. Leclerc, at the bottom of page 2 on 9/11, there was a meeting that was billed at 0.5 hours. Do you see that meeting there?
I do.
Okay. On page 3, towards the bottom as well, on 9/11/25, there is a meeting and it has the same billing entry, correct?
On 9/11, there's two entries, review document and the meeting.
Only the meeting. on 9/11, there are 2 entries that say 9/11 meeting, spoke with client Virginia Leclerc telephonically regarding documents received. Do you see that on page 2 and on page 3?
On page 2 and 3, or page 2 of 3, I do see it.
Page 2 and on page 3, do you see it?
I do.
Okay. So again, you were billed twice for the same task.
Okay,
What was
that's
the
something
entry on page 3? What was the entry, what date was it on page 3?
It's the same date, Your Honor. It's 9/11/25.
I see 3 entries. Reviewed email with additional documents regarding respondent employment social media, and
It's
then
the meeting.
9/11.
The meeting spoke with client Virginia Leclerc telephonically regarding documents received.
Okay, got it.
And
Okay, I see it now. Okay. You may proceed.
Miss Leclerc, how much did you pay for your retainer?
3,000. And I still owe him for some documents and the serving, because that's something he told me that I had to pay. So I still owe him.
Objection, Your Honor, narrative, and she's already answered the
Objection
question.
sustained.
Okay, Miss Leclerc, so you've paid 3,000. Have you paid anything else?
No.
When did you pay the $3,000? On what date?
I don't remember because I made, I believe, 2 or 3 payments for that. One of it, I would like to say that it was the first day that I hired him, which was June the 19th. And then another payment was done June 24th. I made a payment.
How much was the payment on June 24th?
I have one for 127.58. And then I have another payment.
Did you receive anything in writing as to what this payment is going towards?
Yes, it's on my receipts.
Okay.
And it specifies that it's for the child support case, my name versus the father's name.
Does that receipt also include what the work it is that you paid for was?
Just child support case, not a detailed, but yes, for child support, yes.
Okay. Even though you don't have a written contract with Mr. Juarez, are you aware of what your what the fee agreement is, how you are supposed to pay him is?
Am I aware of how I'm supposed to pay him?
Yes, is it hourly? Do you wait till the end of the case? Or is it a flat fee?
It's a combination of both. Because he did tell me that a lot of it had to do with the paperwork involved, the times that he would have to go in case he had to serve him, see how many times I had to go to court. And of course, he did make it clear to me, Miss Leclerc, you do understand that every time that you reach out to me via, a meeting or a text message, like for example, if you go to my office, you do understand that I'll dedicate 1 hour for you. That's going to be a flat fee. Yes, I do understand. Miss Leclerc, do you understand that if I go serve Mr. Martinez, there's going to be an $100 fee or $125 fee. And if we cannot make contact the first time, we have to bill you again. Yes, I understand. So yes, I do understand that there was fees depending on the work involved.
So it's your testimony that essentially your verbal fee agreement is based on a flat fee as well as hourly?
Objection, Your Honor. And
No.
I'm gonna have to object because these are legal terms, it's very apparent, and I can take her on board dire that even though she used the word flat fee, it obviously was not a flat fee. I told her that it was contingent on the amount of hours that were involved, and that's not a flat fee, Judge. But and so I'm gonna have to object to this line of questioning.
Objection overruled. I'll allow you this last question, Ms. Poteet.
Thank you, Your Honor. Ms. Leclerc, on page 1, on 6/24, you were billed for a text message in which Mr. Juarez was advising you of court costs. Is that correct?
I see it.
Okay. So you're being charged to be told what the cost for court fees is. You understand that?
Correct.
I'm sorry, Judge. I missed that question. What was the question, Judge?
The question was if you were charging her or she was being charged
For what
for
date, Judge?
just the cost of the filing fees.
For what date, Judge? And I apologize.
6/24.
6/24.
And I do have, if it makes a difference, I do have evidence of text messaging where on June 24th, that's when I actually made that payment for $127.58. So we did text on that day. Okay, so I'll owe you those fees as well. That was what I sent him. And he replied, yes, these are out-of-pocket expenses. Feel free to send them to
Your Honor, this is hearsay. This hasn't been introduced into the record. She's reading straight off her phone.
Objection sustained.
Ms. Leclerc, yes or no? On June 24th, you were billed for Mr. Juarez to tell you how much the court costs will be.
That's been asked and answered. She said yes. In fact,
Well,
I
think it was
I
some
believe
sort
I
of a
answered that
narrative.
question previously.
Ms. Leclerc, is that just a yes or a no answer?
Based on this, yes, he is charging me.
Okay, it's just a yes or no. Do you need her to repeat the question? Please repeat the question, Ms. Poteet.
Yes, Your Honor. Ms. Leclerc, yes or no? On 6/24, you were billed for a text message from Mr. Juarez where he is telling you about court costs.
It's just a yes or no, Ms.
Yes.
Okay. Next question, Ms. Poteet.
No further questions for this witness, Your Honor.
All right, Mr. Juarez, do you have any follow-up questions from
Yes.
for Ms. Leclerc?
Ms. Leclerc, on August 13th, 2025, in regards to that, you were asked about that, and also August 19th, that there seemed to be a duplicate charge. And you answered that it seemed, your response was that it seemed to have the same wording.
No, it was for 9/11, and yeah, it was for 9/11.
Okay, well, let's talk about 9/11, okay? Was that a duplicate charge?
Well, I still have a balance with you, so I don't know. But if I go based
So
on this,
the answer to the question is, I don't know. Ms. Leclerc?
What I'm trying to inquire, Judge, may I inquire, Judge?
Yes.
Okay, so, well, let's talk first about the August 13th, right? August 13th, there's an entry that says that I talked to you regarding the respondent's answer, correct?
yes,
Okay, and did I text you on that date regarding Mr. Martinez's answer?
I don't even know what to say. They don't let me use my cell phone.
Well, no, you're allowed to, is the answer yes? You can say yes.
Yes,
Okay,
Ms. Leclerc, it's either going to be yes, no, or I don't know. If
Okay,
you don't answer, if you do not know the answer, don't assume, don't guess,
okay.
don't qualify it, don't make a narrative. Just, it's either yes, no, or I don't know.
So on that date, I texted you in regards to the answer that Mr. Martinez had filed, correct?
Yes.
Okay. Did I also respond to you on August 19th in regards to a text that you had sent me um, regarding his answer
Yes.
on August 19th? Okay. So those happened on two separate dates, correct?
Yes.
Even though when you were invoiced, it has the same wording, those were two separate incidents, correct?
Yes.
Okay. So you would agree with me that there were not duplicate charges?
Correct.
Okay. Now, there was also a question in regards to a meeting that we had on September 11th, 2025, regarding documents that you had received. You see that?
Yes, I see them.
Okay. Now, okay. Now, it also says on September 4th that okay, we'll strike that. On September 11th, did we have a meeting where we spoke about documents that you had received?
Yes.
Okay. It also says that on September 4th, I spoke to you in regards to documents that you have received.
Yes.
Okay. And that's also listed as a meeting, correct?
Yes.
Okay. Now, did we speak about documents that you had received in regards to the child support case on September 4th?
We did.
Okay. Even though the entries appeared to be the same wording, you would agree with me that there were two separate dates that we spoke and we met?
Yes.
And they were both regarding documents that you had received. Is that correct?
Yes.
Okay. And just so that we understand, I know that you used the word flat fee, right? Would you agree with me that the agreement that we had was that the more work I had to do, the more hours I put in, the higher your bill would be at the end, correct?
Yes.
Okay. No further questions, Judge. I pass the witness.
Ms. Poteet, any other questions?
Yes, Your Honor. Just for consistency purposes and to show a timeline, Ms. Leclerc, on page 2 in the entry 828, where it says reviewed document, and it says reviewed documents regarding respondent's employment and social media account, do you see that entry?
Yes.
Okay. Does that entry reflect that your attorney received and reviewed documents from you? Is that correct?
Yes.
Okay. A little bit further down on 9/4, you had a meeting, is that correct, in which you spoke with your attorney regarding documents that he reviewed? Is that correct?
Yes.
Okay. So you would agree with me that that meeting is consistent with the billing that he reviewed documents initially, correct?
I don't know.
Okay, I'll keep going. We just went over it, but I'll keep going.
Judge, if we went over it, I'm gonna let's just ask and answer then, Judge.
Well, if she doesn't know, then the response is, I don't know. If you have another question, Ms. Poteet.
I do, Your Honor. I'm trying to get to the point. I promise.
Okay.
Ms. Leclerc, again, on 9/11, it looks like your attorney reviewed documents that you sent to him, additional documents, correct?
Yes.
Okay, you see the word additional in that billing entry, correct?
On 9/11?
Yes.
Yes.
And then on 9/11, right after that entry we just went over, you see the meeting where you spoke with your attorney regarding the documents he reviewed, correct?
Yes.
Okay. So you would agree with me that those two coincide.
They're different.
Would you agree with me that it makes sense that after an attorney reviews something, that they discuss it with you thereafter?
Depending.
Okay. So moving forward to page 3 now, on that entry that we are discussing, it shows 9/11 meeting, spoke with client, the same billing entry, correct?
I see that.
Okay. Above that entry, do you see anywhere where you sent your attorney clients to documents to review, or your attorney reviewing additional documents for you to have a telephonic meeting on 9/11?
On page 3, above 9/11, do I see any charges for what? I'm sorry?
Or your attorney reviewing documents that he received from you?
From me?
Yes.
Attorney Poteet. No.
Okay. So that billing entry is not consistent with the billing entries surrounding it. Yes or no?
I don't understand the question.
That billing entry on page 3 for 9/11 is not consistent with the other billing entries above it and right below it. Is that correct? Yes or no?
Well, it's different. So, no.
Okay, no further questions, Your Honor.
Mr. Juarez, any other questions?
Ms. Leclerc, did you understand what she was asking you?
Not the last couple of questions.
Okay, and so when you said they're different, they're no, you had no idea what she was talking about, right?
Not really.
Okay. Judge, I don't have any further questions.
All right, Ms. Poteet, do you have any, well, do you rest on the motion for attorney's fees?
No, Judge, the only thing I'd like to state on the record is that I did like the Solemn Court take judicial notice of my attorney's fee affidavit that specifically says that that I'm licensed to practice law in the state of Texas, that I do want to put on the record that I've been practicing since 2003. I am licensed. I do family law cases in Maverick County, Texas. Because of the years of experience that I have and the amount of attorney's fees paid in this area, the $350 an hour is reasonable with the years that I have and the amount of work that of cases that I've had in this particular case, Judge. I'd like to also state on the record that the amount that were covered during the period was June 16, 2025 through December 16, 2025 in the amount of $8,750, and that these payments in regards to that, Judge, this is the total invoice that I have that I have charged my client. Every fee that was done was worked on. That I testify under oath that there was no duplicate fees. I also want to state that there are fees. There is work that was done on this particular case that I am not invoicing my client, or I am not asking in attorney's fees, and those are in regards to the judgment that was drafted by Ms. Poteet, Judge. And I do also want to state that I do believe that 350 is reasonable, but I know that it could have been as high as 500, Judge. And so I try to be as reasonable with every entry that I made, the amount of work that I did on each entry, and the amount of fees that I'm charging. And so I'm respectfully requesting that the court award me the $8,750.
Ms. Poteet, your response.
Your Honor, I would actually like the opportunity to cross-examine opposing counsel on the
All right.
reasonableness of his attorney's fees.
Any objections if the court waives the swearing in, the oath? He is an officer of the court.
No objection, Your Honor.
All right, the court will waive Mr. Juarez's taking of the oath. You may proceed, Ms. Poteet.
Thank you, Your Honor. Mr. Juarez, you were privately retained by Ms. Leclerc, correct?
Yes.
Okay, did Ms. Leclerc have a former attorney during this enforcement matter?
I'm sorry, what was the question? She had a what?
Did Ms. Leclerc have a former attorney during this enforcement matter?
I don't believe so. I think she had an initial attorney maybe at her divorce action, but I don't believe she had one on the motion for enforcement.
Okay. Do you have any support staff?
Yes,
Like, what kind of staff do you have?
I have my daughter that helps me review emails and things of that nature.
Is she a legal assistant, a paralegal? What is her job title?
I guess you can say that she doesn't really have a title, but I guess you can call her my legal assistant.
And so you testified that your daughter helps you review emails and review documents. Is that correct?
That's correct.
Um, does your daughter bill at a different rate than you?
I guess the issues never come up because she doesn't. I don't use her on things where I bill where she needs to bill. So, but
Okay.
I guess you can say yes if I really thought about it. Yes, the answer would be yes.
Okay.
She would bill it differently.
So if your daughter was to review an email for a client, who would bill on that invoice? Would it be you or would it be your daughter for reviewing that email?
It's never happened. I guess hypothetically, the answer would be it would be my daughter's rate. Hypothetically, but it never doesn't happen. I think I need to preface by saying that the type of work that she does not include like family law. She doesn't do any of my family law cases. So she didn't do any work on this particular case. So what I'm saying, when you ask me if I have a support staff, yes, I do. What does she do? She does my federal criminal emails. That's what the type of work she does.
Okay. So your daughter has not touched this case at all.
No, she doesn't. She doesn't do family law. She does federal criminal.
Do you have any other support staff?
No, no. From time to time, I do. Someone helps me, but again, in this particular case, they don't do this type of work. They don't do the family law cases.
Okay. You don't have a written fee agreement with your client, Ms. Leclerc, is that correct?
That's correct. It was verbal.
Okay. Is it standard practice for you to do verbal contracts for services with all of your clients?
Very practice. That's like the norm here in Maverick County. In fact, I don't even know if any other attorney. Yeah. So the norm here in Maverick County is it's all verbal agreements, verbal contracts.
How often do you communicate with your clients regarding their contract for your services?
How often for my services? Well, in this particular case, I can tell you that many times, especially like towards the end, every time she would come into my office, I would specifically tell her, Ms. Leclerc, you remember what we said in the beginning when I said the more work I have to do, the more money I have to, that it's going to be more. You remember the amount that I told you initially? So often in this particular case.
Okay. But you just testified that towards the end it was often, but you normally don't regularly communicate about your.
That's not what I said. No.
Feel free to
No.
correct me if I'm wrong, clarify.
You're wrong. And again, in this particular case, I did it a lot towards the end, but from the get-go, I expressed to her where we were at in regards to her fees and how much she owed me.
Okay. Mr. Juarez, would you agree with me that a fee agreement or a contract with your client usually governs what your rate is and what your billable time is and your tasks? Is that correct?
That's correct.
Okay. However, because this is a verbal agreement, how do you keep track with communicating transparency with your clients in regards to what's being billed and what's not being billed?
The transparency can be done through when I put something in an invoice, as my client has testified. Everything that I put in there, she went and double checked to see if I had actually done the work. And every entry that I made on there, in fact, she pointed out a whole bunch of times where if something I wrote in there, there's either an email, there's a text, there's something that highlights that work was done. So in regards to transparencies, just because I don't have a written contract, doesn't mean that there isn't transparency. Quite the opposite. I mean, everything and she testified that there wasn't no duplicate charges in regards to the work that was done. So I would say that it's very transparent.
You would agree with me that if you were to have a billing dispute with a client, for example, in this case, not having written documentation showing your contract with the client could pose an issue. Do you agree with me on that?
In regards to pose an issue, I don't believe that there is any conflict with my client in regards to the billing, first off. And then secondly, is there things that we can do better or improve, or there is, but again, that doesn't necessarily mean that how I did it was illegal or unenforceable. Now, you're asking me, can I do things to better my practice? Yes, of course. Just like there's a lot of things that you could do also to better your practice.
Mr. Juarez, if you were to be audited by the State Bar of Texas on this case, how would you prove that you actually have a contract with your client and you were hired by your client?
Very easy. Ask her. That's 101. The only I don't know if Ms. Ms.
What
Poteet,
was the,
how can I prove if I was audited? The question was, how can I prove if I was audited by the State
My
Bar?
question.
right. But your response was to ask Ms. Leclerc?
Yes, to ask her if she hired me. Like if I want to prove whether she retained my
got it.
services, you all you do is just like what I did is I ask her.
So you
Contrary to popular belief, on these types of contracts or agreements, they're enforceable because those are enforceable contracts. That's 101. The only thing that has to be in writing is real estate, and there's a couple of other ones, the statute of frauds. There is nothing in the code that says that I have to have a written contract with a client on a family law matter. There's nothing I'm violating ethically with the State Bar if they were auditing me. So how would I prove to the State Bar that she was a client and I'm rightfully charging her?
Mr. Juarez, as a licensed attorney for 20 plus years, I'm sure you're very familiar with the Texas disciplinary rules of professional conduct, right?
Yes.
Okay. I'm sure that you're also aware that Rule 1.04 states that you need to communicate the basis or rate of the fee, preferably in writing before or within a reasonable time after commencing representation with your client, correct?
I would have to review the rule, but I'll take your word. I don't have any issues with that.
Okay.
That sounds right.
Okay.
Any other questions, Ms. Poteet?
So the first time you sent invoices to your client was December 26th when you filed them with this court, correct?
Written, that would be correct.
What was the first date? December of
26.
2025?
Yes.
No, yes. She's asking me if I ever sent her an invoice of everything that specifically I
Got it.
did. And
The
that
very-
was the first time. That was the
The
first
very
time
first
that, right.
invoice was sent on December 26, 2025.
That's correct.
And your testimony, as well as your client's testimony, is that you were hired on June 19th, 2025, correct?
And that's correct. And I just want to make sure that the first time that I did a written one, that was that day.
Um, So 6 months after being hired was the first time your client saw the task that she was being billed for.
That's incorrect.
Wait a minute. I thought you said the first time you sent her an invoice.
It was,
Was
Judge, but we had spoken
invoice.
about certain things before. Like
No, I
the
think
other
the
things were just
question-
in writing, but in written, yes, that was the first time.
Okay,
It was
got
6
it.
months.
Okay.
But
So the
that doesn't.
answer is yes.
No, well, the last question was different because the last question you didn't tell me written. You said
I
that she
did.
had ever seen a task, and the answer is no. I had told her, look, you're getting billed for this. You're going to get
All right,
billed for
why
that.
don't you repeat the question, Ms. Poteet, just to make sure we've got a solid answer to the question.
Yes. Mr. Juarez, the first time your client saw a written invoice showing the tasks that you worked on was December 25th, 6 months after you were hired.
That's correct. Written, yes.
Okay. No further questions on this line or this line of questioning, Ms. Poteet. What were you requesting, or what is your
Your Honor,
closing
I would
argument?
like to highlight some specific entries that I believe are unreasonable, and I wanted to highlight them to the court.
Okay, just let's start on page 1 then.
Okay. Mr. Juarez, the first 4 invoices, the first 4 billing entries were for an initial consultation, correct?
That's correct.
Okay. And so it is correct that when you have an initial consultation, you had not been hired yet.
So I believe that, see, had I not gotten paid for being hired, that is correct. But I believe that from the time that I spoke with her, that there's already attorney-client privilege, there's already that established. And so,
Okay. But those billing entries are regarding her retaining your services. So it was not actual substantive legal work done on the case.
no, it was substantial legal work done on the case because in regards to whether, number one, whether we have a conflict or what are the issues, we're talking about her case in particular, specific facts and cases. So that's like the heart of how, in regards to substantial work, yes, that's very much so, very substantial in this.
Just for the interest of time, I just want to highlight on the very first entry, you use the words regarding retaining my services, correct?
That's correct.
Okay. These charges on 619 regarding an initial consultation, those were incurred before reviewing any documents or preparing any pleadings, correct?
I'm thinking that no, but I don't recall exactly when she had given me the documents, but I think it was the same day. And I need to review my records, but
Okay, so is your answer an I don't know?
yeah, I don't recall. I don't remember.
Okay.
Oh.
Would you agree that it is common practice for attorneys to charge a flat consultation fee rather than an hourly billing to induce retention?
Not what? I mean, okay, repeat that one more time. Is it commonly what?
Would you agree with someone who has a wealth of years of experience that it is common practice for attorneys to charge a flat consultation fee rather than billing hourly?
Maybe in San Antonio, but in regards to like a consultation fee, like I know I've heard that there's some attorneys that say like, hey, um, I'm gonna charge you this fee, and if you don't get hired or whatever, then that's all you have to pay me. But
You're saying no, it's not common practice based on.
not in Maverick County. No, that's not the way we do
Okay.
things. And you would
Uh,
never get any clients that way.
okay. Would you agree that it is standard practice for attorneys to use templates when drafting?
Yes, I agree with that.
You filed a notice of appearance on 6/23, where it says document preparation, prepared and drafted notice of appearance. Is that correct?
That's correct.
Okay. That notice of appearance is approximately 2 sentences long, correct?
I need to look at it. It might be a little bit more, but yeah. And then it also includes the style of the case. It also includes the certificate of service, and there's other things that are required from it. Yes,
But you did say earlier that it is standard practice to use templates.
that's correct.
Okay.
I'm not disagreeing with that.
You billed on 6/23 for drafting a notice of appearance, 0.5 hours. Is that correct?
That's correct.
You bill in increments of 6 minutes, right?
Yes, whatever point one is. Yeah, I don't know if it's 7 or 6 minutes, something like that. Yes.
So is it your testimony that based on your billing entry, it took you 30 minutes to draft a notice of appearance?
And that would be correct.
Okay. You also billed right below that 0.5 to prepare and draft a motion for enforcement. Is that correct?
That is correct.
Okay. Your motion for enforcement is approximately 4 to 5 pages long, right?
I believe so. It is.
And you would agree that that is a more substantive and novel motion containing legal issues in this case, right?
When compared to a notice of appearance?
I'm just talking about the motion. You would agree that it is a more novel motion, that it
More
has
novel to, that's what I mean, more novel, when you say more novel.
to the
more
issues
novel
of the
than-
case.
But in regards to what, more novel than to another document?
Just in general, it is a novel document. It is a motion with substance. Yes or
Yes,
no?
I would agree with that. Yes.
Okay.
I wouldn't necessarily say more, but yeah.
So it is your testimony that those 2 documents required the same amount of time according to your billing entry?
According to the billing entry, yes.
Okay.
That's what I placed on my invoice.
When did you draft this invoice?
That I actually wrote it, drafted that invoice. I think it was sometime in December 2025.
Okay. So did you estimate how much time it took you to draft these documents at the time?
No, I have notes in my intake sheets. Like when I do entries and stuff like that, I take notes.
You have a timekeeping system?
I don't have a computerized entry thing, or no, I don't. Like no one tracks like from this hour to this hour I'm doing this. So the timekeeping system that I have is when I start and then when I finish. So
Okay. So you just keep track, it's all in your head pretty much.
no.
Okay. Do you write it down?
Yes, it's everything that I have is written down. I have proof of everything that I did. There's a written form, so yeah.
Okay. You filed the motion for enforcement and the notice of appearance on the same day, correct?
That's correct.
Okay. By filing the motion, you were already acting as counsel for Miss Leclerc, right?
I was acting as counsel with a notice of appearance.
But you filed at the same time.
Just for clarity, Mr. Juarez,
Yes, Your Honor.
you will agree that your motion for enforcement was prepared and drafted I'm assuming shortly thereafter it was filed, but your bill says June 23rd. The notice of appearance would have been a notice of appearance as to the confirmation of arrears, correct?
Let me look at my notice of appearance, Judge. I think it was through the whole case, but it might have been to, hold
It
on.
might have been because the motion to confirm support arrears was filed by the Office of the Attorney General. I'll give you the date, April 4th.
Right.
So I'm assuming that you filed a notice of appearance to their confirmation of arrears. And you also filed a motion for enforcement.
I think I did it all at the same time, Judge. It was like the same time that so my practice is
You would have been filing a notice of appearance on your own case?
no, I would have been filing a notice of appearance on the case. Like I'm the attorney for this case, which involves not only their answer, but anything that I file, and just announcing that I am the attorney that's going to be representing her.
On the confirmation of arrears, correct?
Yes, Your Honor, on the confirmation of arrears, but
Your Honor, if I may, I would just ask that the court take judicial notice that that language is nowhere in the notice of appearance of counsel.
well, that's what I was going to tell you, Judge. I know that I know this court, and I don't want to be disrespectful to the court, but I know that you're asking me was the order, if it was regarding that, but the language that I use is representing this cause of action.
I understand that. I think maybe what the court is thinking is that when you file a motion and your motion for enforcement was an original pleading, that constitutes something in the file that says you are representing her on the motion for enforcement. And so I just need to clarify it because the family code states that for motion for enforcement, attorney's fees are mandatory, but not the confirmation of arrears. So it just seemed that by looking at the file that the notice of appearance would have been in response to the confirmation of arrears, because your motion for enforcement itself would note that you are the attorney that filed the motion for enforcement. But maybe I'm wrong. If it's your testimony that you filed a notice of enforcement, that you filed a notice of appearance in relation to your enforcement, I guess that's how it happened.
I'll tell you, Judge, when I do it, and I'll be candid with the court, like I just have practice that I have, because sometimes and I'm not saying this court, but just in general, they'll be like, did you file your notice of appearance? Even though I filed a different pleading. And so I just do a notice of appearance for the entire case, and that's what the language reads. And then also, it's just a better practice. I don't know.
Honor, I can continue my line of questioning, but just as a response to Mr. Juarez, I just would like that the court be able to take notice that there is no local rule in Maverick County that requires an attorney to file notice of appearance in addition to their initial pleading. But additionally, on top of that, what I'm alluding to in my line of questioning is that this is an unnecessary expense. Whether it be to Ms. Leclerc or to Mr. Martinez, to anybody really. There was no need for an entry of appearance to be filed at the same time.
Judge, I would beg to differ. So like from now
I
on,
can move on with my questions so we can move on to the topic.
And Mr. Juarez,
notice of appearance, that's not, okay, all right, Judge, continue. I'm sorry.
that's okay, Mr. Juarez. It's one of your smaller
Yes.
items. What the court can tell you is the court's reasoning is there was a motion for confirmation of arrears filed, the notice of appearance.
I hear what the court is saying, Judge.
And so you know what? The family code doesn't say attorney's fees are mandatory on confirmation of arrears. So that's how the court is going to look at it.
Yes, Your Honor.
As far as that entry in your billing.
Yes, Your Honor.
You may proceed, Ms.
Thank you.
Poteet.
Thank you, Your Honor. Mr. Juarez, on 6/19, you billed to review the motion to confirm support arrears filed by the OAG. Is that correct?
On 6/19, review motion. Yes.
Okay. On July 8th, a little bit lower from page 1, Mr. Juarez, you billed the full time to attend a hearing on both the motion to confirm arrearages and the motion for enforcement, correct?
That's correct. I put both of them on there.
Okay. You did not segregate the two.
No, I don't think the court segregated it, so I just combined it.
But you didn't segregate them in your billing.
No, I just put them as one entry, but it was because we were dealing with both issues on.
Understood. Again, on 7/8, you billed for both, again, speaking to your client regarding motion for enforcement, but additionally to speak to your client regarding the motion to confirm arrears.
I billed one more time, I'm sorry.
On 7/8, you billed for time spent speaking to your client regarding the motion to confirm arrears. Is that correct?
That's correct, right. And then as opposed to the hearing, yes.
Okay. Mr. Juarez, again, on 8/26, you billed to attend a hearing, and that included the hearing on motion to confirm arrears, correct?
Yes, that's the bill says.
Okay.
Yeah.
Still on page 2, Mr. Juarez, on 9/16 in that billing entry, you billed to go to a hearing in regard to the motion to confirm arrearages. You billed for that, correct?
And along with the motion for enforcement, yes.
Okay.
That's
On page 3, Mr. Juarez, on 10/23, you billed to review an email from the OAG regarding that final order to confirm arrearages, correct?
That's correct.
And again, on 10/23, Mr. Juarez, you billed to review the AG's proposed order regarding confirmation of arrearages, correct?
Correct.
Mr. Juarez, I just want to highlight back to page 1. I want to highlight on 7/3, July 3rd, you have 3 billing entries in which you review file stamped documents, correct?
That's correct.
So on 7/3, you billed to review file stamped pleadings that you yourself drafted and filed?
That's correct.
Okay. A little bit further on the following. So question, in reviewing the file stamp documents, was the substance of the documents changed at all?
Well, I checked for that. If that's what you're asking, did I check for that? Yes. I need to make sure that whatever I submitted was what got file stamped.
The question was, in reviewing the file stamped copy, that does not change the actual substance of the document you filed, correct?
I wasn't looking whether.
Okay.
I wasn't what I was looking for to make sure that what I filed got received and did, and that it got received and that it was in the court's file, and that what I filed was actually what they were putting in the record.
Okay. On July 5th, you billed point 3 to draft one email to express process regarding costs. Is that correct?
That's correct.
Okay, that email involved no legal analysis, correct?
Yeah, it did. Yes, that's incorrect.
It included legal analysis?
Yes.
Okay. Can you just briefly elaborate how we're discussing cost of services can include legal analysis?
So then you need to talk about whether he got served or not, whether that was filed timely for the hearing. In regards to, there was a possibility that if he didn't show up to the hearing, then we were going to have to, what steps we would have to take in regards, because you got to understand that this is a motion for enforcement. So now we're talking about him doing jail time. So unless he was properly served and given that, then we can't proceed with that. And I need to explain to my client in regards to that. But luckily, at the end of the day, that was moot because your client showed up. Because I believe that he actually technically got only served with one of the documents and not the other one, or there was some issue there, and that's why first of all, that's why the email was lengthy. It wasn't like, hey, by the way, the client got served. No, it was like an analysis of, look, we sent the documents over, and it was like 3 days before the hearing or 4 days before the hearing. I just want to let you know that we sent them out, but they returned one and they didn't the other. And I think that's even the reason why I was explaining to my client that we're still waiting for the bill for the service, for a service, but we never got it. And I think it was because he didn't actually get served on one or something along the lines. And I remember that I had to explain all of that to her, because what I didn't want to do is for us to show up, because my client was very adamant that she wanted to proceed right away. And so I had to make sure that I explained to her, like, look, we might not be able to proceed because he's barely.
I'm going to have to object to narrative, Your Honor.
Objection sustained. And I understand your answer, Mr. Juarez.
Yes, thank you, Judge.
Okay. Mr. Juarez, just for clarification purposes, and so there's a consistency. What you were testifying to regarding the issues regarding service and the actual act of serving him, you billed 1, 2, 3, 4, 5, 6. You billed a total of 6 different entries and times above the one we were discussing, in which you talk about process service, discuss citation of service, and even regarding service of citation with your client. Is that correct?
That's correct.
Okay, so what you were testifying to earlier, you already billed for that, and that wasn't my question.
No, and that would be incorrect. No, I had
Okay.
not billed already. There were separate issues. Every entry is separate, and
Okay.
I don't double bill.
But as reflected on your billing entry, that 7-5 entry shows that that discussion was for one email regarding cost of service.
That's correct. That's correct. That's what it reflects.
Okay. Would you agree with me that that is purely an administrative nature email?
As I explained to you, no, because it was just not that. It wasn't just, look, this is how much it is. Here's your bill. It was a lengthy discussion about what.
So is it your testimony today that your invoice is not accurate?
No, it's accurate.
Okay. I was just confused because you're telling me that there was more to that email, but your invoice reflects that it was just the one topic of cost.
It doesn't say only that, Ms. Poteet. So I think your confusion is you're assuming that that's the only thing that I did on that particular thing. But I mean, believe me, if I had to put every little thing that I did on this particular case, then this case would be astronomical, and that wouldn't be reasonable. And so when I look at an email, I either look at the subject line, and that's what I put on it, But that doesn't necessarily mean that that's the only thing that we discuss.
Do you bill the client for putting in your billing entries?
No, I'm just saying that I didn't.
It was just a yes or no.
Right, no, I didn't. No, in fact,
Mr.
I don't.
Juarez, on 813, which is on page 2,
Mhm.
on 813, you billed point 2 to email my paralegal, Veronica Hernandez, regarding dates to confer. Is that correct?
That's correct.
Okay. And that email simply listed 3 dates in which you were available, correct?
I don't recall, but I wouldn't disagree with you.
Okay. Would you agree with me then that that does not require legal analysis?
I can tell you in regards to those types of entries, okay? Uh, in regards to, it's not just drafting and, strike that. In order for me to prepare that documentation to get the dates, I need to go back and look at the issues that the case has because I have a lot of cases and I need to remember exactly. So on that particular case, I had to see, okay, what are the issues here? Let me go back so that I can then do a scheduled meeting with you. And so it's not just like the
So-
actual physically writing of the email. I need to go back and check to see what it is. I opened the email. I said, okay, they want to meet with me about this. Okay, what are the issues that I need to discuss with this attorney so I can tell her what time I have available? So then I got to go back to the file. I open the file. I review the documentation, the legal analysis. Then I go back and I say, then I got to look at my calendar to see how it is. So that's why it's just not a 0.1 or something like that. I mean, it takes time so that I know what I can write on an email, what dates I have available. Because if it's a very, very complex matter, then I know that I need to schedule more time.
Okay.
So I would disagree with you on
Mr.
that.
Juarez,
Yes,
so
ma'am.
is it your testimony that you bill the client to review the file numerous times, the same documents that you've already reviewed?
Of course, you have to review a document more than
So-
one time.
So you bill the client twice for the same work?
No, I did not bill the client twice for the same work. What I'm doing is I am reviewing a client's file to see if there is any additional work that I needed to look at to see if. So no, I never double bill a
Okay.
client in regards to that.
So Mr. Juarez, so it is your position that in order to provide me with 3 dates that we can confer, you had to open the client file and review the issues in this case?
And to see if I have not missed. And not only that, but you see what happens is that
It's just
yes,
yes or
yes,
no. Okay.
yes, I have to go
And
and
you
review the
build
file. Yeah,
you build a 0.2 for that.
whatever. Yes, that's correct.
Okay. On the entry 916, you put you billed 0.5 hours to review documents regarding respondents' unpaid bills. Is that correct?
Which one? 9 what?
On 916, you have a billing entry that says review documents regarding respondents' unpaid bills, correct?
That's correct.
What unpaid bills are you alluding to in this billing entry?
I think it was like he has a lot of unpaid bills. I think there were like medical things, and because at that time we were talking about including on the motion for enforcement, not just that the he hadn't paid the child support, he hadn't paid the medical support, but he hadn't paid like medical actual bills. And my client wanted to discuss that we were going to include that in the motion for enforcement. And so she brought me documents and she said, I remember her telling me like, hey, I want to include this on the motion for enforcement that we have. And so I reviewed those documents. And your client got lucky that we didn't include that because we might have been able to enforce that too.
Mr. Juarez, in reviewing your motion, you did include medical expenses in that motion. So is it your testimony today that you reviewed unpaid medical bills in 9/16, even though your motion was filed on 6/23?
Yes, because I reviewed, if you have an entry is when I reviewed those documents. So I think my petition, when I initially she had told me that, and we had included that, but I actually didn't have the physical documents, and because she would bring me in different documents at different times. So every entry that I have is I receive new documents.
So is it your testimony then that the amount you alleged in your motion is not accurate because you didn't have the actual documents for the unpaid medical bills?
No, how would that doesn't even make sense, Ms. Poteet. No, what? How? No,
So,
no.
Mr.
The answer is
Juarez,
no. The answer is no.
okay. You allege on your motion that was filed in June that you were asking for medical expenses and you put in an exact number of how much you were requesting, correct?
I would, yes.
Okay. However, you did not review actual unpaid medical bills, the amounts, until 9/16.
That's not true.
Isn't that what is reflected in your billing entries?
That's not true. That doesn't reflect that.
Okay. In that same billing entry, did you review the unpaid child support by Mr. Martinez?
On what entry again?
On the entry of 9/16, where you reviewed documents regarding respondents' unpaid bills, did you also review respondents' unpaid child support?
No, I think that was just separate bills that she had brought me. So no.
Okay. Moving on to on 9/30, page 3, you billed, there's 2 entries that you billed reviewing an email from the judge and reviewing an email from myself. Is that correct?
That's correct.
Okay. Did you forward these emails to your client?
I don't recall.
Okay.
I don't recall.
But you didn't reply to these emails, correct?
I
There was no response on 9/30.
No, there wasn't a response on 9/30. Ultimately, there was a response, but I didn't bill for those. So when I ultimately responded, I didn't bill for those.
Okay, so there is no notation showing any action taken as a result of your review of that email?
Yes, there is, and prepared and drafted email to judge regarding order on 10/1, but I didn't bill for that.
In just a minute, Ms. Poteet. Ms. Urubaso, if you wish, you're excused since this is just the hearing on the motion for attorney's fees. You are excused.
Thank you, Your Honor.
Unless you wanted to stay, that's fine too.
No, thank you, Your
Thank
Honor.
you.
Good luck to both of you. Thank you.
Mhm.
Bye.
You may proceed, Ms. Poteet. Sorry, I realized she was still waiting.
Okay, thank you. Okay. So is it standard practice for you, Mr. Juarez, to review an email from a judge and not respond when a response is requested?
Judge, I'm gonna object the relevance. I didn't bill for it.
Ms. Poteet, your response to the objection.
Your Honor, he did bill. He billed to review the email, and he didn't make an action on it. He didn't forward it to anyone. He didn't make a response.
That's correct, Judge. I did.
There is
The
no
next day I
proof showing
replied.
that he actually reviewed the email.
I reviewed it and I replied.
All right, both of you, just to let you all know, I didn't grant those charges because we did have a hard time getting him to respond to the order. Ms. Poteet had to prepare the order, and so the court did. There's only 2 entries, $35 and $35, because the rest he didn't bill. So the court did not grant those anyway.
Thank
So
you,
you
Your
don't
Honor.
have to answer that, Mr. Juarez.
Thank you, Judge.
I can move on. Mr. Juarez, on 10/17, you billed to review my email where I provided you the proposed draft of the final order, correct?
Yes, yes,
Okay. You did not respond to that email when you reviewed it, correct?
I responded it later. Yeah,
Okay.
that's correct.
On 10/17, you billed 0.5 to review the final order, correct?
That's correct.
And on 10/29, you billed again 0.5 to prepare and draft the proposed changes and corrections to the final order.
That's correct.
So you billed based on your billing entry a total of 1 hour to make corrections.
That's about right. Yes.
Okay. Those corrections consisted of 3 minor red line markings, is that correct?
Not only that, but to actually review it to make sure that it didn't have any additional. So I wouldn't know what corrections are made unless I review the entire document. I can't just say, well, because I only found 3, then I'm gonna bill you less, even though it took me the time to review it. So
you had already billed the time to review it, but it took you the same amount of time to make 3 red line markings.
What do you mean by red line markings, Ms. Poteet?
I mean, I can introduce it as an exhibit if there is no objection.
I'm just trying to figure out what red line markings was in relation to the entry. Because the entry you're talking about is, it's not the one for confirmation of arrears.
No, so the entry that I'm talking,
1029, the one on 1029.
yes, that he billed the same amount once to review it, and then the same amount of time to he drafted and prepared proposed changes and corrections. And my question to Mr. Juarez is, it took you 30 minutes to make 3 markings on a document.
Your response, Mr. Juarez.
that's correct. It took me 30 minutes to prepare and draft proposed changes and corrections to Attorney Poteet's final order.
Your Honor, if I am able to introduce this document as an exhibit to be able to provide a visual to the court.
Any objections, Mr. Juarez? Or you all can verbally tell me the 3 red line changes were.
I used 3 changes and they were stricken like that. It was a PDF file, so I had to get a program to do it. It's not just like a Word document. I had to get a PDF converter thing, and I have to through it through a red line, and then I have to type it in. And it's not just like a Word or like, oh, it's, yeah. I mean, so I have no objections. I mean,
Okay. Your Honor, I don't know what would be the best method for me to show the court the document that I'm referring to.
Well, I have a question, Ms. Poteet.
Yes, Your Honor.
I do recall that we were trying to get the order submitted. Mr. Juarez filed the motion for enforcement, so he should have prepared the order, but it was never done. So I emailed both of you all regarding the final order that we had not received it. You suggested that you would prepare it. So these changes you're referring to, were they responses by him and then you filed it with the court? Or you filed it with the court and it had already been submitted to the court and he suggested the changes after it was already filed?
Your Honor, I sent him the proposed final order, the draft before filing on October 17th. I did not get a response until the day I actually filed it, which was
Okay.
October 29th. And due to the delay, I didn't want to keep going in circles, so I unilaterally filed it. I had sent it to Mr. Juarez as a professional courtesy, but I had not heard from him in over 2 weeks. And when I filed it was when he emailed me, even though he
Right.
had reviewed the document
And
before.
and the court will take judicial notice that it was finally signed by the court November the 4th, in response to the fact that we have not gotten it. So I don't need the 3 red line. I don't need it.
Okay. Mr. Juarez, the Attorney General's proposed order for confirmation of arrears, you did not sign that order, is that correct?
Relevance, Judge?
They usually don't file it. Are you talking about the confirmation of arrears order, which was signed, well, it was heard September 25th?
Yes, Your Honor. It was circulated to the parties for review. I reviewed it and I also signed it. So I was
Okay,
just asking
is
Mr.
there
Juarez if he had signed
a
it.
bill for that one?
That's what I'm objecting. She's asking for things that I,
Yeah, not if he didn't bill for it.
He did bill for it, Your Honor. He billed to
Where is
review
it?
the email on 10/23 and 10/23. He billed to review the email and he billed to review the proposed order, but he did not do anything with it. He just billed to review it.
Okay, I see that.
Mr. Juarez, you billed for hearings that we had on 9/16 and 12/16 in this case, correct?
yes.
And your billing reflects the entire time block for those hearings that we had?
Yes.
And Mr. Juarez, isn't it true that during those hearings, you were also handling another court matter at the same time?
I don't recall, but I would imagine so.
Okay. And that additional court matter was for another client?
I would imagine so. Was I doing multiple things at the same time? Yes, I was.
Okay. So you billed the full time to both clients, is that correct? Based on your entry?
No. I billed one client their time, and I billed Ms. Leclerc a different time.
Okay. But you just testified that the billing entries for those hearings that the 9/16 and 12/16, that they reflect the entire time block. You did say yes to that, correct?
Yes, Miss, because that was the entire time block for Ms. Leclerc.
Okay. So at
So
no
yes,
point did you have to take a recess to represent another client during our hearing?
I don't remember how many times but whatever I did was the entire time that I was with Ms. Leclerc, and the answer is yes. That's what you asked me, and that's what I answered.
Okay.
Now, if you're asking me whether I'm double billing because I was at another hearing, no, I didn't.
No further questions, Your Honor.
All right, Ms. Poteet, I know Mr. Juarez was asking for attorney's fees pursuant to his billing, which is a total of $8,750. What was your request as far as attorney's fees?
Your Honor, our request is, this is a wash, essentially. There are numerous, as you've heard in the testimony, there are numerous billing entries that do not correlate with the enforcement. There are numerous billing entries that are duplicative, that are not substantive with transparency as to what the task was. And these are considered unreasonable, and some of these entries were not necessary, as we heard from the testimony. And additionally, Your Honor, my client had to bear a burden in which I had to take over to draft the final order, which I know Your Honor has already admitted as judicial notice. But that is something that should be taken into account in regards to my drafting. And not only drafting, I had to review the emails, respond to the emails to keep Your Honor informed as to where we're at in the status. So I did my due diligence in keeping the court informed and keeping my client informed. And unfortunately, my client is bearing the burden of that. And now Mr. Juarez is wanting to come back and take another bite of the pie. So initially, Your Honor, we are asking that attorney's fees not be granted. And we're asking that this occur under Texas Family Code 157.167C, in which this court is allowed to waive Mr. Juarez's request for attorney's fees award for good cause shown. I'm showing to the court that there was a clear disregard for the Texas Disciplinary Rule of Professional Conduct 1.04b, in which Mr. Juarez did not consistently communicate regarding the basis or the rate of his fees.
Judge, I'm sorry. I don't normally object when they're making their argument, but I take great issue that Ms. Poteet is even hinting that I did something that is unethical. And I want to put that on the record. I just want to make sure that I protect and I put that on the record that I take great issue and I take great insult that she is attacking me as my professional courtesy and my ethics. Judge, I understand that you have to fight zealously for your client and attorney's fees, but to stoop so low to accuse me of being unethical, Judge, I'm not going to stand for that. And I want that to be on the record, Judge, respectfully.
What the court is going to take note of is the court isn't even considering that, Mr. Juarez, and so Ms. Poteet, I don't need that kind of a statement because I don't have jurisdiction for disciplinary actions and things of that nature.
And Your Honor, we're not asking for disciplinary actions. We are not asking for an ethical review. I am simply painting the picture to the court to show that Mr. Juarez is attempting to have
Ms. Poteet, I don't want any implication either because he did testify. So I don't know if any of these statements and whether maybe he should have been warned, you know what, go ahead and remain silent if you wish, because we were only considering testimony regarding the charging. And so I'm not going to consider it. So no longer on that area.
Yes, Your Honor, I understand. I am merely arguing as to the reasonableness of the attorney's fees. There is a Texas Supreme Court case, Romis Venture versus UTSW Healthcare LLP in 2018, in which the court must determine the time, labor, skill, and necessity of the work done in regards to the actual billing entry to determine whether there was reasonable attorney's fees. And based on the Texas Family Code in which Mr. Juarez is relying on regarding getting awarded attorney's fees for the enforcement, it does say in verbiage that the attorney's fees has to be reasonable and necessary. And based on Mr. Juarez's billing entry, I noticed and I highlighted there are patterns of some excessive entries. There are patterns of some administrative billing, which has also been ruled in the Texas Supreme Court that attorneys are not allowed to bill at the full attorney rate for administrative tasks. They either have to bill at a legal assistant or paralegal rate, or they would just eat the cost as overhead of the firm. And so I just want to highlight that Texas law is clear. Clerical and administrative tasks are not commensurable for attorney's fees, and they are considered unconscionable. Here, the billing reflects duplication, micro billing, and it does not show that it materially advanced the legal substance of the case, which is what the whole crux of that section of the code in which attorney's fees is granted for enforcement is based on. And I would just also like to add, Your Honor, ultimately, at the end of the day, my participation along with my clients was necessitated, and by his financial circumstances, family obligations, all of those things. But my client has already bared the burden of keeping up to date with his child support payments, in which he satisfied his deferred adjudication while he also has to maintain his basic minimum needs as well as his family. At this point, based on these fees and an additional $8,750, we are setting up Mr. Martinez for failure. His income is fixed and limited a substantial portion of that income is already legally committed to his court-ordered child support arrears, and the remainder is consumed by his basic living expenses.
What do you mean by additional 8,000? Wasn't that $8,000 payment part of the arrears of
No, Your Honor.
35,000?
What I'm stating for the 8,750 is that Mr. Juarez is asking that the court award an additional $8,750 in attorney's fees.
Oh, got it. I'm sorry, I thought you were referring to the 8,000 that we appeared today for to confirm that the payment went through, but that was child support arrears that were owed to Ms. Leclerc. Okay,
Yes,
I
my
got it now.
apologies for confusing that. But yes, Your Honor, essentially, the attorney's fees, we have gone over them. Many of them include tasks that are regarding the confirmation of arrears. And that is not allowed per the same statute. And so all I'm asking from the court is that this is a wash. Essentially, my client is already legally committed to paying his court-ordered child support arrears and getting that finalized. On top of that, he has paid the burden of having me take over the final order and getting that finalized for the court. We are not asking for that be paid out or given to me. We are just asking that it be canceled out. And so we are requesting that no attorney's fees be awarded for either Mr. Juarez or myself at this time.
All right.
May I respond to
they-
briefly? May I respond?
Yes.
Judge, I take great issue with Ms. Poteet claiming that we set up Mr. Martinez for failure. Mr. Martinez set Mr. Martinez up for failure. Let us not forget that it was him and only him that owes my client $35,000. $35,000, Judge. My client didn't do anything. That was Mr. Martinez. And the only way that we got the $8,000 is because my client had to file a motion for enforcement. And because of that, she had to spend money, Judge. And so for this notion about it's going to be a wash, Judge, because Ms. Poteet drafted one order, her one order, I guess, paramounts to $8,000. Now that's unreasonable, Judge. Now, if you look at every fee that I have, number one, I made sure that everything that I actually did, every work, painstakingly went through everything that I had, all my notes, every email, everything I reviewed, I made sure of it. Everything was substantial. There is, Ms. Poteet keeps saying that there was no duplicate. There was nothing duplicative. Not only was there nothing duplicative, that I made sure that things that I thought that, you know what, this court is probably not going to award me, I am going to go ahead and not include it. And for the overabundance of caution, I went through everything and I reduced certain fees because I wanted to be reasonable. Even though I had spent more time, I went ahead. For example, the part about the notice of appearance and the motion to enforce, Judge, I spent more time on the motion to enforce, but it appears like they're the same entries because I actually reduced the motion to enforce. Because after I said that, I said, look, you know what? Let me go ahead and reduce that. So also on the notice of appearance, she makes a big thing like it was only two lines. It's not just 2 lines, Judge. When you're going to file a notice of appearance, you got to make sure that you have the right cause number. You got to track down the cause number. I mean, there's a lot of things that go into it. But be that as it may, having said all of that, Judge, I can tell this honorable court that there is nothing here that is duplicative. Everything was substantial. I drafted everything. And we're just respectfully requesting this honorable court and I understand that there's some things that this court is not going to grant me, and I understand that, but that this thing about it being a wash, Judge, respectfully, that would be an insult and a slap in the face to the judicial system and also to my client, Judge.
All right. The court is obviously taking judicial notice that the motion for enforcement was filed. I had it right here. Hold on. I have the court's entry. The motion for enforcement was filed on June the 23rd, 2025, at the time that the child was already 19. The court is also taking judicial notice that there was no other motion for enforcement filed The only thing that was filed by the Office of the Attorney General was a motion for confirmation of arrears, of which there was an order granting the arrears. The court found that Mr. Martinez owed $35,229.27. So the court sees that the motion for enforcement was what did get him to pay. He was in substantial arrears and the child was 19. The court is granting attorney's fees of $2,200. I did note that the motion for enforcement was filed in June. There were 2 resets. One of them was at the request of Mr. Martinez because he wanted to hire an attorney. Mr. Juarez, the substantial amount of your billing was in combination with a confirmation of arrears. So obviously what the court did in that is I just divided it by 2 because we all know and are aware that at the time that the Office of the Attorney General has their cases, obviously it's for all pending motions. And so you did make an appearance on your motion because it had already been filed, but not all of it was attributable to the motion for enforcement. So the court will grant attorney's fees of $2,200, of which you will get a judgment. Mr. Juarez, you can collect on that judgment under the rules of civil procedure. The court is giving both parties the notice of their intent. If they wish to file a request for a trial de novo, you've got 3 business days from the date that the order is signed. You can file it. That part is appealable to both the parties. Mr. Juarez, I'll give you 1 week to prepare the judgment. It's your motion. Again, you didn't prepare the other one. Ms. Poteet had to file it. So you need to file it by next Friday.
Yes, Your Honor.
All right?
Your Honor.
Yes, ma'am.
I'm so sorry. I just wanted to clarify, is there any way that we can request, instead of a full judgment, that my client be allowed to be able to do payment plans to fulfill the ruling of the court?
I think that would be the most reasonable, Mr. Juarez, because for you to obviously enforce and try to collect and get bank records, take depositions and all that, it's just probably more feasible and reasonable for Ms. Leclerc to start receiving payments on that. And obviously we can include that in the judgment. Any objections, Mr. Juarez?
No objection, Judge.
All right, so Ms. Poteet, did you want to confer with Mr. Martinez to see what or if you all want to give me an amount?
If I can just take a brief 1 minute, we don't have to go to a separate room. I could just call my client on mute, just so I can confirm, because I don't feel comfortable agreeing to something without confirming with him first.
That's fine. Do you want me to put you in a chat room? That will probably give you more privacy.
If that's easy.
If you want to call him by phone, yeah, we can just put you on mute. We could do that.
Okay, I'll be on mute. I'm finished, Your Honor.
All right, Mr. Juarez, did you have an opportunity to visit with your client?
I think he might have stepped away for a second.
Okay.
Oh, there he is.
Back.
Mr. Juarez. All right, Ms. Poteet, your response with respect to the attorney's fees granted.
Yes, Your Honor. I spoke to my client and he can reasonably afford $200 a month. For 11 months, he would finalize the $2,200 payment within the year.
Mr. Juarez.
What I'm respectfully requesting is if he can make an initial payment and then the remainder of $200. So if he can come up with maybe half of it, Judge, and within a month, and then the remainder in payments. That's what I'm going to be respectfully requesting.
You know what? All right. What the court will do is grant a $200 payment. What the court did is divide it by 12 months. The child is 19. Obviously, the statute of limitations, even though this is attorney's fees, but is the age of 20. So the court will grant a $200 payment beginning February the 1st. Again, either party can appeal the decision as long as you do it 3 days from the date that I signed the order. So Mr. Juarez, you can include that payment plan in your order. That way, if you wish to appeal it, you can.
I'm sorry, can you repeat the payment plan is $200 a month for the next?
No, $200 a month. The attorney's fees of $2,200 is being granted. He's
Okay,
to pay that at $200 a month beginning February the 1st.
February 1st.
So that's what your order is going to reflect.
Yes,
okay.
Your Honor.
All
Okay,
right.
Judge.
How would my client best make the payment, through the same way he pays through the OAG, or just make them directly?
No, I don't think the OAG is going to control it, and she's left and I excused her, but I'm almost sure that if you send it in, because there's an arrears of
It might go straight to the
30,000,
arrears.
it might go straight to the child support. So what you can do in your order, Mr. Juarez, is go ahead and put a clause in there that he's ordered to make payment to you. I don't know how you want to do it, whether your address, money order, or how.
Okay, Judge, I'll speak with Ms. Poteet,
I don't
so
think
he
you
can
should-
make it directly to me.
Yeah, I don't think it should be a direct deposit. Now, if you want to, because it's attorney's fees, have them pay her directly.
That's the other thing, because I know that aside from what they're right now, what they're withdrawing from his paycheck is only 100 and some odd. So I know that he needs to make additional payments because the child support is at 800. So he needs to be making payments to her directly because they're not taking enough out of his. So if he can make that additional payment to my client, it just make sure that
Yeah.
in whether payment it is that he separates, like this is for child support and this is for attorney's fees.
Right, well, your order is going to state that he owes $2,200 at the rate of $200. He can pay it directly to her. It just can't go through the Office of the Attorney
Right.
General because on their financial statement, there is no column for attorney's fees. And
Okay.
if he sends it to you, he can, but then she may be waiting for you.
Right,
You
and that's
have
what I'm saying. I'll just send it directly to her because anyway, he still needs to he needs to make direct payments to her right now because he's not paying what he's supposed to be paying. And we don't
Well,
want
I
to come
don't
back
know.
in a
The
month or
order-
two.
The confirmation of arrears order reflects his payment plan. So Mr. Martinez, on the attorney fees, just pay him directly to Ms. Leclerc. I would talk to Ms. Poteet after I excuse you all, just to make sure that it gets documented. So if for some reason or other, they don't get the payment or whatever, you need to keep track of how you're paying her directly.
Yes, Your Honor.
Okay.
Certified
And-
mail, is that okay?
That's fine, certified
Certified
mail, whether it's a check or a money order,
Money order?
money order is fine, Mr. Juarez, because you may be able to follow up with a motion for enforcement on the attorney's fees. I would be very specific and put that it should be with a money order and not a personal check. So make sure you put that in your order,
Yes, Your Honor.
okay?
Yes,
All
Your Honor.
right, then you all are excused. Thank you very much.
Ms. Leclerc, could you please state your name for the record?
Virginia Leclerc?
And Ms. Leclerc, there was a prior order modifying a suit affecting the parent-child relationship that was signed back in September 17th of 2019. Do you recall that modification and order?
Yes.
Okay. According to that modification, child support was going to start at $628, or it was modified, I should say, to $628 per month, and medical was going to be at $151. Was the $151 to reimburse you for coverage that you had through your employer?
Yes, what happened is that the father was continuously, like, he was providing the health insurance, but then he would default, and when I would have to go to the doctor, it was always it wasn't a valid insurance. So what I did at the time, I was married, so my ex-husband, we put it under his insurance. So I needed to continue the health insurance. So Mr. Martinez was reimbursing me, I believe, like a fraction of the cost of that insurance.
Okay. And so I'm not sure if our child support officer had an opportunity to go over the financial activity report that was provided by the Office of the Attorney General to show payments that were made and not made. Did you have an opportunity to look at that?
Did I have an opportunity to look at the financial report?
The financial activity report that was provided by the Office of the Attorney General. It was also attached to the motion to confirm arrears, this petition.
That's the one from 2019, because the only thing I saw is pretty much the documents that were emailed to me. And then I sent,
You want to show it on the screen, Ms. Urubaso?
Yes. Let me go
Thank
ahead
you,
and
Ms.
share it.
Urubaso.
Mhm. Let me go ahead and share it. So this is the financial activity report that was provided by the Office of the Attorney General. Let me open this up, open in browser. Okay, let's see. We got this share. Here we go. Okay, can you see my screen?
oh
You may
yes,
have to
that's the one.
enlarge it a little bit. Can you enlarge it a little bit, Ms. Urubaso?
Yes, I will. Better?
Yes.
Okay, great. All right. So, Ms. Leclerc, this is the financial activity report that was provided by the Office of the Attorney General. It has the, wait, this does not look like, no, this is wrong. Sorry. What in the world? Hold on, Your Honor. I'm so sorry. That does not look like the right fee.
Mhm. I saw that as a financial report, and it tells you like all the payments that have been applied and the balance from like, I guess from when the child started till, I guess the recent payments.
Yes.
Uh-huh.
I'm going to go ahead and show it to you anyway. I just need to get the right one up. I'm so sorry about that. Okay, here we go again. Let me enlarge this. Wait a minute.
Mhm.
What the? Oh, God. Sorry. This is not right. Stop sharing. There we go. Okay, sorry about that. Let's see if I can get this unlocked. No, it's not going to let me. Can y'all see that right now, or is it too small?
I can see it.
I can see it.
It's fine.
Okay. All right. So this is a financial activity report. Sorry about that. This has your name, Virginia Leclerc, Mr. Rodolfo's name, Rodolfo Martinez, and then it has the amounts that were due from that prior order starting in what we have here, January of 2019. There looks like there was a judgment. And so let's see, we got any payments here. Child support amounts applied. It looks like there was a collection from potentially the IRS in 2019 for $5,000, and then another one in May of 2019 for another $5,000. Oh, God. This is not scrolling either. Sorry about that. Let's see what is happening here. Your Honor, it is not, my screen is not working with me. Let me try to stop sharing and share again. I'm sorry about that.
All right. And Ms. Poteet and Mr. Juarez, you all were looking at the financial exhibit A. First of all, while she shows it again, you all have seen it. Was there going to be any objections to the admissibility into evidence?
No objection, Judge.
Ms.
No,
Poteet?
No.
All right. And while she's doing that, was there a dispute as to the arrears and the payments, or were you all stipulating to the arrears amount?
We're stipulating, Judge.
Yeah,
Ms.
we're
Poteet?
stipulating to the financial report sheet.
Okay.
Excellent. Thank you. Let's try this
Can you
again.
give us the amounts, Ms. Urubaso?
Okay, Your Honor. I'm so sorry. There was
That's okay. We just need to move the docket along.
okay. So let me go down to the bottom since both parties are agreeing to the arrearage amount. I have as of August 31st, 2025, an amount of $35,229.27. That is for child support arrears. Then we have a medical support arrearage as of August 31st, 2025 in the amount of $24,227.47.
Okay.
Ms. Leckler, it looks like everyone is stipulating to the amounts that are provided by the financial activity report. Did you receive any payments directly from Mr. Martinez?
Never.
These are the only payments that you received through the disbursement office.
Correct.
Okay. Your Honor, I have no further questions. I'm sorry.
All right. Ms. Poteet and Mr. Juarez, do you all still need the financial statement on the screen for questioning?
I don't, Judge.
I don't believe so, Judge. I just wanted a clarification. The amounts that were just read into the record, are those from August 31st, so they don't show a reflection of a payment made in September. Is that correct?
Correct.
It does show a payment there. If you notice at the bottom.
Leclerc, no, Ms. Leclerc, you have an attorney and so we can't, just hold off and we'll ask you in a minute. All right, Ms. Poteet, which payment were you, because there's a September, but she's getting her judgment only as of August the 31st. So the August of the 31st, if you see the arrow, is going to reflect what she read into the record. Since they are not asking for arrears amounts after August 31st, we don't need to go into the payments, but we can acknowledge that the money was paid. It's just prior to the time of the judgment.
Yeah, thank you for the clarification.
Thank you, Ms. Urubaso. You can stop sharing.
Your Honor, the state would like to also offer this as Exhibit A.
We already have. It's been admitted into evidence as Exhibit A.
Thank you, Your Honor. That's all. That's all I have for Ms. Leclerc. I'll pass the witness.
Okay, Ms. Poteet, did you have any questions of Ms. Leclerc at this time on the arrears? Let's just take it one step at a time. On the arrears.
At this time, regarding the arrears, I do not.
Okay, Mr. Juarez, any questions regarding the arrears?
Yes, Your Honor. If I may.
Yes.
Okay, Ms. Leclerc, in regards to child support payments, okay, on November 1st, 2019, in regards to child support payment, would you agree with me that the respondent was to pay $628 in child support?
That is correct, as per the court order.
Right. And would you agree with me that on November 1st, 2019, you did not, the respondent, Mr. Rodolfo Martinez, did not pay $628? Is that right?
I'm not looking at the financial report, but I understand that the payments have not been continuous.
Okay. And I need for you to look at the financial report because I need to make sure that that particular date you did not receive a payment.
Okay.
Objection. I thought we were only asking questions in regards to the arrears. This sounds like enforcement questions.
Yeah, Mr. Juarez.
All right, Judge. In regard to that, then, in regards to the arrears, just if we're inquiring whether they're calculated properly, then I don't have any I don't have any questions in regards to that, Judge.
Yeah, I think right now the court is just trying to establish whether or not, because we've already admitted the financial statement into evidence. So the parties stipulate the past due amount of Mr. Martinez is $35,229.27 as of August 31st. And in medical is $24,227.47. We aren't getting into payments or anything like that yet.
Yes, sir. Then I don't have any further questions on those regards.
Ms.
Urubaso, yes.
I do have a follow-up question, if I may.
Yes.
Ms. Leclerc, how much did you or your husband pay for the health insurance premiums?
I believe it was about $100. The total amount for his insurance was $200 and something, but but when we actually went to court in front of a judge, the judge, I believe it was ordered to pay $100 and something. It was a portion of that insurance. It was not like the full insurance.
Do you know how much it was just for the child to be covered?
I believe it was about 147, 100 and I can look it up. I have the documents here, but on top of my head, no, I don't remember the amount. But it was about $100 and something. I cannot specify the exact amount.
Well, and Ms. Poteet, I'm not sure where your questioning is going to, but there was a prior order that was dated September 17th, 2019. The court is taking judicial notice of that, and it obligated him to pay $628 a month in child support and $151 in medical.
151. Okay, I just wanted that clarification, and I just wanted to know if the medical had changed from that date till now.
Okay.
But if it stayed the same, then that's fine.
No, that's fine. I thought you were questioning as to why it was more than the amount it cost, which should have been done in a motion for new trial or something like that.
No.
Ms.
I was just
Leclerc-
wondering if the health
Yeah.
insurance had changed. Ms. Leclerc?
Ms. Leclerc, the question,
It changed last year. It changed as of July when the child turned 18. I dropped the insurance. So
Okay.
July
Yeah, it
16th.
did not change.
No, it
All right.
changed until I dropped the insurance coverage when the
Ms.
child
Leclerc,
turned.
just a yes or no, just a yes or no. And Ms. Urubaso, it is strictly a motion for arrears. You don't have a motion to modify on hand, correct?
No, Your Honor, we do not have a motion to modify as the child has
So
already
we've done,
been activated.
we've done the arrears portion.
Yes, Your
Are you done with your line of questioning, Ms. Urubaso?
I am with Ms. Leclerc. Yes, I can ask Mr. Martinez just a few questions.
Yes, you may. You may proceed.
Thank you, Your Honor. Mr. Martinez, could you please state your name for the record?
Yes. Rodolfo Martinez, ma'am.
And Mr. Martinez, you had a chance to review that financial activity report. You can put your hand down. It's okay.
Thank
The financial activity report that was provided by the Office of the Attorney General, and you are not in dispute, as your attorney said, to the arrearage amounts. Is that correct?
That is correct.
Okay. All right. I have no further questions.
All right. Ms. Leclerc, do you have any questions of Mr. Martinez?
Not at the moment, Your Honor.
All right. Mr. Juarez, any questions?
I'm sorry, did you ask my, I don't have any questions of it. No.
Okay. All right, then we can begin the motion for enforcement. Just for purposes of the record, the Office of the Attorney General did file a motion for arrears, to confirm arrears. That was their only motion. Mr. Juarez, you have filed a motion for enforcement. So I believe those are the two pending motions before the court, correct?
That's correct, Judge.
All right. So
Yes.
Mr. Juarez, if you'd like, you can begin your presentation on your motion for enforcement. Who
Yes,
would you
Your
call
Honor.
as your first witness?
My client, and I'd like this honorable court to take judicial notice about documents in the file, specifically what has already been introduced in this hearing.
I can't
Which
take
is-
judicial notice of the entire file, but I can take judicial notice of certain things. And one of them I can take judicial notice of is the prior order.
The prior order, Judge, and also I'd like to incorporate into my hearing the exhibit that has already been introduced.
The financial statement.
That's correct.
Yes, it's being, I'm not taking judicial notice of it, but it's being introduced as an exhibit and it will be attached to the order.
Okay.
Okay.
I'd like to call Ms. Leclerc.
Yes, Ms.
Yes.
Leclerc, they're going to ask you a couple of questions.
Yes.
Can you say your name for the record?
Virginia Leclerc.
Ms. Leclerc, what is your son's name?
His name at birth was Rodolfo Martinez Jr.
Okay, and he's a male, and what is his date of birth?
His male is July 16 of 2006.
Okay, and he is the subject of this cause of action, is that right?
That is correct.
Okay, and we filed the first amended motion for enforcement, is that right?
Yes.
Okay, now in regards to that, there was a prior order, is that correct?
Yes.
And that was on November 21st, 2011?
Yes.
Okay. And then after that, there was a, and then after that, there was a subsequent hearings. Is that right?
Yeah, those are hearing after.
Okay. In fact, there was a temporary order ensued for modification of support order and to confirm support arrearage. Is that correct?
Yes.
Okay. And on that particular order, there was an order that Mr. Rodolfo Martinez Jr. was to pay child support. Is that right?
Yes.
Okay. And just for the record, he is a father. He is the father, correct?
Rodolfo Martinez is the biological father, yes, of Rodolfo Martinez Jr.
Okay. Now, in regards to this particular case, specifically on November
and-
1st.
And Mr. Martinez, hold on a second. The court will take judicial notice of the first amended motion for enforcement. However, I don't know if there was a prior judgment on the arrears, so I don't know if some of this questioning would be res judicata. Were you going to be trying to enforce as your 2011 order or your 2019?
No, I'm going to start with the 2019 order, Judge. So it's not a
So
res
then any
judicata.
questioning for 2011, we'll just
Right.
not get into. You may proceed.
That's correct. Okay. So on November 1st, 2019, was the respondent, Mr. Martinez, was he ordered to pay $628 in child support?
Yes.
On November 1st, 2019, on that particular date, did he pay $628?
Well, he's been very inconsistent with his payments, but
I understand, but in order for us to prove the amended motion, we need to be very specific as whether he paid or he did not. On that date.
no, there's
ma'am,
not a payment for that day.
right.
All right,
And
now,
did you
Ms.
receive?
Leclerc, the questions are strictly yes or no questions, okay?
Okay.
So did he pay?
No.
Okay. Now on December 1st, 2019, was Mr. Martinez ordered to pay $628 on child support on that date?
Yes.
And did he pay the $628?
No.
Okay. On January 1st, 2020, was Mr. Martinez ordered to pay $628 in child support?
Yes.
Did Mr. Martinez pay on January 1st, 2020, $628 in child support?
No.
On February 1st, 2020, was Mr. Martinez ordered to pay $628 in child support?
Yes.
On February 1st, 2020, did Mr. Martinez make a payment of $628 in child support?
No.
Okay, on March 1st, 2020, was Mr. Martinez ordered to pay $628 in child support?
Yes.
On that date, March 1st, 2020, did Mr. Martinez make a payment of $628?
No.
On November 1st, 2021, did Mr. Martinez, was he ordered to pay $628 in child support?
Yes.
Did Mr. Martinez on November 1st, 2021, pay $628 as he was ordered?
No.
Okay, on December 1st, 2021, was Mr. Martinez ordered to pay $628?
Yes.
Did Mr. Martinez pay on December 1st, 2021, $628 towards child support?
No.
Okay, on January 1st, 2022, was Mr. Martinez ordered to pay $628?
Yes.
On that particular date, January 1st, 2022, did Mr. Martinez pay $628?
No.
On February 1st, 2022, was Mr. Martinez ordered to pay $628 for child support in this cause of action?
Yes.
On that particular date, February 1st, 2022, did Mr. Martinez make a payment of $628 towards his child support?
No.
On March 1st, 2022, did Mr. Martinez make a payment of $628?
No.
Was he ordered to pay that amount for child
Yes.
support?
Yes.
On November 1st, 2023, did Mr. Martinez make any child support payment on that date?
On November of 2023?
That's correct.
No.
Was he ordered to pay on November 1st of 2023, $628?
Yes, he was ordered.
On December 1st, 2023, was Mr. Martinez ordered to pay $628 in child support?
Yes.
On that date, December 1st, 2023, did Mr. Martinez pay $628?
No.
On January 1st of 2024, was Mr. Martinez ordered to pay $628 in child support?
Yes.
On that date, January 1st, 2024, did Mr. Martinez pay $628?
No.
On February 1st of 2024, was Mr. Martinez ordered to pay $628 in child support?
Yes.
And on that date, on February 1st, 2024, did Mr. Martinez make a payment of $628?
No.
On March 1st, 2024, was Mr. Martinez ordered to pay $628 in child support?
Yes.
And on that date, did he make payment of $628?
No.
Okay, so would you agree with me that as of July 31st, 2025, there was a Mr. Martinez owed $59,527.37. Do you agree with me on that?
Yes.
Right. And now the way we come up with that amount is we basically give him we figure out how much he was supposed to pay child support. Is that correct?
Yes.
And then we subtract any payments that he made, correct?
Correct.
Okay, so what was his history in when he gave payment? Like, when did it happen?
When did it happen? His payments were very inconsistent. So my understanding, most of the payments were either done right before we would have to go to court, like every 3 years. We would have 2-3 months prior to court. We will make $200-$300 payments. I did get a couple of lump sums back in about 2019 when the previous attorney represented. I believe he was ordered to pay me $10,000 within a certain time period, and then he made a payment. Earlier this year, I believe March or April, I also had a virtual, I guess, like a negotiator from child support, and he made a couple of payments. And then after that, he stopped making payments. That's when I retained of your services so that you could help me enforce this on this matter.
Okay, so would you agree with me that the only time that Mr. Martinez makes payments, it's either through lump sum or when we're getting to court? Is that correct?
Yes. Yes.
Okay, now having said that, has Mr. Martinez ever been held in contempt of court? Meaning, has a judge ever ordered any type of punishment because he has failed to pay?
Not that I know of, no. There's
Okay.
never been.
Are you requesting the court to find him in contempt of court for failing to pay the child support?
At this time, yes.
Okay, and in those regards, are you specifically asking that he be held in contempt of court because of July 31st, 2025, Mr. Martinez failed to pay $59,527.37? Is that correct?
Yes, it is correct.
And would you agree with me that the respondent has been in arrears for more than 30 days for some portion of the amount due and is in arrears for an amount equal to at least 1 month's support? Is that correct?
Yes, that is correct.
Okay. Would you also agree with me that you listed 15 separate violations in your petition?
Yes.
And on each violation, you're asking that the respondent be held in contempt and be jailed for up to 180 days for each violation? Is that what you're asking?
Yes.
And you're asking, and he be fined up to $500? Is that correct? Okay. And you're asking that these terms run consecutive? Is that right?
Yes.
Okay. Are you requesting that if the judge chooses not to, in the alternative, that if instead of directly issuing a contempt order for him being fined, that if he were to be, that we wouldn't have an issue if he were to be placed on some kind of a community supervision for 10 years?
Correct.
And so that if he fails to make a lump sum payment and some amount that he will, then we can ask the judge to automatically jail him?
Correct.
But our first request is that he be jailed immediately, correct?
If possible,
Okay. Now, in regards to that, what is your understanding that Mr. Leclerc, does he work? What is your understanding?
Mr. Who? Mr. Martinez?
I'm sorry, Mr. Martinez, yes. I apologize. Where does he work?
To my understanding, Mr. Martinez is an active real estate agent in San Antonio.
So it's your understanding that he has a license?
He does. He has an active license.
Okay.
Yes.
Okay, and in regards to that, what leads you to believe that he is an active real estate agent?
There is a portal that you can actually monitor and see any active real estate agents, and it goes by the name, their phone number, and he shows listed. He is also active on social media, and if you go to, like for example, Zillow, whatever other, market, real estate market, you can see where he is. He has different listings, recent listings. I can go as recent as maybe late August, where he is selling properties. I did come across a report where Mr. Martinez has sold, I believe, about 33 homes in this year.
33 homes this year?
Approximately, yes. Under Premier Realty Group. I did show his license number being Texas license 633-911. A lot of these, he has represented the buyer. Homes were sold back in August the 29th, July 28th of 2025, July the 3rd,
Your
2025.
Objection, Your Honor, narrative and assumes facts not in evidence yet.
And plus it may be hearsay. Objection sustained.
Okay, now, in regards to your understanding, only if, we'll strike that. Do you know if Mr. Martinez has a vehicle?
I do know that he has a couple of vehicles. Not sure if they're registered under his name, but I believe there is a, when I brought it up to court last time, it was a Honda Civic and a Mercedes-Benz.
Okay, a Honda Civic and a Mercedes-Benz. Okay, and do you know if he has a home?
He does. There is a property listed in San Antonio under the 5107 Erickson Bluff in San Antonio, 78247. It's registered under Rodolfo Martinez and Elia Martinez.
Okay. And now, give me 1 second. That's I pass the witness.
Ms. Poteet, do you have any questions of her?
Yes, Your Honor.
You may proceed.
Thank you. Ms. Leclerc, a couple of preliminary questions. The child is 19 years old right now, is that correct?
Yes.
And the child currently does not live with you, correct?
For college purposes, correct.
Yes. It's just yes or no.
No.
Okay. The child is currently incarcerated, is that correct?
Incorrect.
Okay. Was the child recently incarcerated?
Incorrect.
Okay, so the child has never been incarcerated in the past 3 years.
That is correct. Not incarcerated.
Okay. And so where's the child right now?
He is living in San Antonio, Texas, attending the University of Texas in San Antonio.
Has the child ever been arrested?
No.
Objection, Your Honor.
Your
Uh,
objection, Mr. Juarez.
Yeah, relevance, Judge.
Ms. Poteet, your relevance on an enforcement.
I was just trying to obtain some factual background information as to the child currently, but I'll move on, Your Honor.
Yeah, objection sustained.
Ms. Leclerc, you recently testified that you would prefer to send Mr. Martinez to jail. Is that correct?
If it's a yes or no question, yes.
Okay. And you're aware that while he's in jail, he's not able to provide payment for child support, correct?
Objection. assuming facts not into evidence.
You did question her on whether she wanted him in jail, so objection overruled. You may continue, Ms. Poteet.
No, Judge, but it's automatically saying that he's not going to pay when he's in jail. And my experience is that's when people pay, is when they're in jail.
Well, he's not paying right now. And he's
Ms.
not in jail.
Leclerc,
He's not paying.
don't respond,
Sorry.
Ms.
I'm sorry,
Leclerc.
Judge. Yeah.
No, it's not you, Mr. Juarez. Ms. Leclerc, do not respond when the attorneys are stating their objections. All right,
Okay.
so the question was whether if he's in jail, the question to her was, you do know whether he's not going to pay. And Mr. Juarez,
Speculation.
your objection was?
Speculation, Judge. How it's not true. Just because you're in jail.
Question.
Okay, she's going to rephrase it.
Ms. Leclerc, while a person is in jail, are they able to work in their employment?
I'm not sure.
So, do you believe that Mr. Martinez is able to have substantial employment while in prison? Is that your belief?
He probably can inside jail. Yes.
Okay. And so your belief is that while he's in jail, he's going to be able to make payments of $628, I believe, dollars monthly while he's in jail. That's your belief?
There's a possibility.
Okay. And so for 180 days jailed for 15 violations, that would amount to 2,700 days in jail. Is that correct?
Let me make the math and I'll tell you in a minute. So you're looking at 180 times 15 violations. That's 2,007. That is correct.
Okay. And so there's a potential that you could or could not get paid child support while he's in jail for 2,700 days, correct?
That is fine.
Okay. And you're okay with that?
Yes.
Okay. So this isn't about him paying his child support, right?
Objection, Your Honor. Relevance.
Ms. Poteet, your response to the objection.
Your Honor, this is relevance because it suggests retaliatory motive. I'm just setting the scene for it. So.
Objection overruled. You may continue.
So, Ms. Leclerc, this isn't about you receiving child support, right? This is about you wanting to see him in jail.
Objection,
Poteet,
Your Honor. Asked and answered.
I have
allow
not.
that one question. Ms. Leclerc, that's either a yes or no.
No.
Okay. We can move on, Ms. Poteet. But
Yeah.
because I believe the elements on the motion for enforcement was there a court order that obligated him to pay child support? Did he pay it or not?
Ms. Leclerc, before this enforcement was filed, since 2019 to now, have you attempted to reach out to Mr. Martinez at all in trying to get payment?
No.
Okay, so you made 0 attempts to get payment. Is that correct? That's what-
Correct, because there's no communication.
Okay, so would you agree that the child's basic needs were met throughout that time? Is that correct?
They were through me, yes.
Okay. And isn't it true that in 2019 you did receive 2 $5,000 payments?
Yes, I did.
Okay. And are you also well aware that of the COVID-19 pandemic that occurred around 2019, 2020 time?
Yes, I'm aware.
Okay. And you testified earlier that you were aware that Mr. Martinez has an active real estate license and that is his profession, correct?
There's active. Yeah.
Okay. Do you have personal knowledge? Or are you aware that the real estate industry was hit particularly hard during the COVID-19 pandemic?
I'm unsure.
Okay. But that is around the time you did notice a drop of his payments, correct?
Incorrect.
So you did not testify earlier that around the end of 2019, beginning of 2020, all throughout that time, you did not testify that he missed payments?
For the last 5 years, we've missed payments.
Okay, so
Or
specifically,
since the 2019,
okay, so
inconsistent.
okay, so he had inconsistent payments since 2019.
Inconsistent payment, yes.
Okay. And isn't it true that when you guys went to court to try to mediate this case, he offered you a lump sum payment, but you refused? Is that correct?
When are we referring this to the March with the mediator?
There was
Or can
two.
you specify?
There was two I can specify. There was two instances. There was the hearing with the Office of Attorney General end of last year, and then there was a meeting earlier this year.
That is correct.
Okay. And you refused both times a lump sum payment from Mr. Martinez.
Judge, I'm gonna object to this line of questioning because it's
Yeah,
talking
it may
about,
be negotiation.
right, that's negotiation, Judge.
So objection sustained.
Okay.
And besides, I think the order, I'm not sure, I'm almost sure that the order would reflect that the payment should have gone through the disbursement unit.
It did, Your Honor. Are we clarifying regarding the two $5,000 payments question that I made?
No, she's already asked and answered, and there were no objections to that one. I think the question right now that you were asking is whether or not she was offered payments through negotiations and that she turned them down.
Correct. And so, Ms. Leclerc, you've turned down good faith attempts to negotiate in turn because you want jail time, right?
Objection, Your Honor.
Incorrect.
Objection sustained.
Okay. I'll move on. I'll just ask a couple of foundational questions of
Okay, you may proceed.
Ms. Leclerc, are you currently employed?
I am.
Okay. What is your current job title?
Does it matter?
You need to answer that, Ms. Leckler. How are
Director
you-
of Operations,
Okay. How long have you been working as a director of operations?
23 years.
Okay. And what is your monthly income?
It fluctuates. I don't have a consistent monthly amount.
Rough estimate is fine.
Of, I don't know, 6,700.
And you have a spouse, is that correct?
Not at the moment.
Okay. Do you have any other children?
I do not.
Okay. No further questions, Your Honor.
All right, Ms. Urubaso, do you have any questions for Ms. Leckler?
No, Your Honor, not in regards to the enforcement issues.
All right, Mr. Juarez, do you have any other witnesses on your enforcement motion?
Judge, I'd just like, if I could be allowed to question Ms. Leclerc, just a couple questions, Judge.
Okay.
Ms. Leclerc, are you asking this court that Mr. Martinez pay a lump sum?
Correct.
How much are you asking that he pay?
Whatever the judge feels it's fair due to based on the amount that is due.
Okay.
But I have been offered very small amounts for the amount, and that is the
We're not
reason.
getting into negotiation,
I'm
okay?
I'm just asking if there's an amount that you're asking, and this is your time to tell the judge. Is there an amount?
30,000,
Okay, you're asking for 30,000. Okay,
maybe,
no further
or
questions.
20.
No further questions, Judge.
All right. Do you have any other witnesses, Mr. Juarez?
Yes, I'd like to call Mr. Rodolfo Martinez.
All right, you may proceed.
Can you state your name for the record?
Rodolfo Martinez,
Mr. Martinez, where do you reside?
5107 Erickson Bluff, San
Okay.
Antonio, Texas, 78247.
Who do you live with?
I live with my wife and 3 children.
Do you own the home?
No, sir. I make payments on that home.
How much is the house worth?
The house is worth probably about $350,000.
How much do you owe on it?
I owe maybe about $325,000.
you're in the real estate business, correct?
I'm in the real estate business, yes.
You agree with me that your house has at least $25,000 in equity, correct?
No, it doesn't have $25,000 in equity. I
How
wouldn't know.
much how much do you believe it has in equity, your house?
I mean, I owe it all.
I'm not asking if you owe it all. I'm sorry. I'm sorry. Okay. You testified that the house is worth 350,000, correct?
Roughly.
Right.
347, 350, correct.
Right, 350, right? And
Correct.
when I asked you how much you owed on it, you didn't say 350, you said 325,000. Isn't
That is
that your
correct.
testimony? Right?
That
Would
is
you
correct.
agree with me that the house has equity then?
I mean, from what I understand from the loan process, they give you 80% of the value, right? And so
I'm not asking about the loan process. I'm asking about equity. Does it have at least $25,000 in equity? That's what I'm asking.
I mean, I don't understand your question because I owe that.
It's very simple,
property.
Mr. Martinez. That's what I'm asking. Is if a house is worth $350,000, like you said your house is worth, and you owe $325,000, wouldn't it then lead to believe that there is $25,000 in equity? I'm not asking about loans. I'm not asking
No.
how much it would take.
I don't believe that there's 25,000. No, sir.
Okay. Now, do you own how many vehicles do you own?
I have one vehicle that I own.
Okay, what kind of vehicle is it?
That is a Honda Civic.
Okay, and do you how much is that worth?
That vehicle is probably worth about 15,000 or no, hold on. It's probably worth about $25,000.
Okay, how much do you owe on it?
I owe about 30,000 on it.
Okay, so you would agree with me that that's upside down, correct? Meaning
That
that
is
there's no
correct.
equity on it, right? How much is your monthly payments on that?
The monthly payment on that is about $560.
$560. Okay, how much is your mortgage payment?
The mortgage payment is about $2,300.
Okay. Does anybody in your house or do you, anybody in your house or you drive a Mercedes?
I do drive a Mercedes.
Okay, and whose vehicle is that?
That is my wife's vehicle.
Okay, and you drive it, correct?
That is correct.
Okay, and you bought it during the marriage, right?
That is correct, yes.
Okay, now how much
Well, my
is owed
wife
on
bought
that
it during
vehicle?
the marriage. Let me read.
Right.
My wife bought it during the marriage, correct.
Right, and on the Mercedes, how much is owed on that Mercedes?
About $7,000.
How much is it worth?
I don't know how much it's worth. No, sir.
What year is it?
It is a 2019, sir.
And what kind of class is it?
It is a C300, sir.
Okay, and how much do you pay a month on that?
I don't know. My wife, she makes the payments on those, so she probably pays about $250.
Okay, how much you pay electricity every month?
I'm not aware. Maybe about $250 to $280.
Okay, and how much you pay in cell phone?
Cell phone payment is about $185.
Okay, what about insurance?
Insurance has gone up, and so it's roughly about $1,000 a month, 980 to
And what do you
1,000.
pay insurance for?
For the vehicles,
How many vehicles besides the Mercedes and the Honda Civic?
one more vehicle, so there's 3 in total.
What's the name? What kind of vehicle is it?
It's a GLE 350 Mercedes. It's an SUV,
How much is that worth?
maybe about $55,000,
And how much is owed on it?
about 60,
Okay,
65.
and how much do you pay on that vehicle?
She pays about $1,200 a month.
Okay, and who drives that SUV Mercedes?
That's what my wife drives.
Okay, who drives the Honda Civic?
My son drives the Honda Civic.
Okay, how many vehicles have you gotten the son that you have with Ms. Leclerc?
How many vehicles?
Yeah.
He's had 2 vehicles in his life.
No, I'm asking how many have you paid for?
For Rodolfo Martinez Jr.,
Yes.
no vehicle, sir.
Okay. Now, would you agree with me that, okay, where do you work?
Right now, I work at HEB.
What do you do at HEB?
I work as a deli clerk.
Okay, and how much do you make
I make $16.50
an hour?
an hour. That is
How
correct.
long have you been working there at HEB as a deli clerk?
I've been there for 2 weeks now.
2 weeks?
That is correct. Yes, sir.
Okay,
Oh,
did you get
I'm
that
sorry.
job?
I'm going on 3 weeks. This is my 3rd
3
week.
weeks. Did you get that job because you were coming to court?
I got that job because I want to fulfill my obligation to the child support. And so working a full-time job and having my payments directly come out of my employer is the best way for me to be able to pay that. Yes, that is correct, sir.
Okay, and I guess, do you still have a active license as a real estate agent?
I do, but I probably won't have one.
I didn't ask anything else, but whether it's all I asked is whether it's active.
Yes, that is correct.
Okay, what was the last home that you sold using that real estate license?
I don't recall, sir.
Okay, was it a rough
It was,
estimate, like a month
I don't
ago?
know. It was a little house.
No, I'm not asking if it was a little house. I'm asking how long ago? Like, is a month ago, a week ago, 2 weeks ago,
This was a month ago,
or 1 month ago?
August.
Okay, in August.
Right.
Okay,
Yes,
all right. And you made commission out of that house, correct?
that is correct.
Okay. Now, you heard every violation that Ms.
Hold on a
Leclerc
minute,
tested.
hold on, Mr. Juarez. Mr. Martinez, how much commission did you make on the sale of that house that you just sold a month ago?
It was maybe about $6,000, ma'am.
All right. You may
Okay,
continue,
now-
Mr. Juarez.
Okay. Aside from that one a month ago, prior to that, what was your previous house or previous real estate that you're in commission?
I don't recall, sir.
What do you, in this year, how many? Okay, so in the real estate business that you have, do you sell homes or what do you sell?
I sell homes. That is correct.
Okay.
Yes.
How many homes would you say that you've sold from January 2025 to the present?
I don't recall, sir.
Rough estimate. 1, 2, 3, 4.
Maybe I don't know. I'd have to check.
Yeah, just give me a rough estimate. Is it more than 10?
No, sir.
Less than 5?
Maybe about 5 or 6. Yes, sir.
Okay, 5 or 6. And generally, how much do you make commission on each of the homes?
Maybe about $5,000-$6,000. Correct.
5. Okay. Aside from working at HEB, are you still selling homes?
No, sir. I'm going to be working HEB full time.
Okay, so if you sold 5 homes up till now, and each home you get 5,000 to 6,000, you've made a commission about $36,000 so far. Is that right?
No,
this
sir,
year?
because I have to pay taxes on all that. Yes, sir.
Right. Okay. While you're working, how much did you
And I'm
make last
sorry,
year?
can I plug in my computer? Because I'm getting a low battery for my computer. Let me plug it in.
In the meantime, Ms. Urubasa, do you have any other agreed orders that we can do? So we won't keep people waiting.
Your Honor, we have defaults.
Okay.
Mhm.
While he's plugging in Ms. Poteet and Mr. Juarez, let me go ahead and take at least one default. Ms. Urubasa, which one is it?
We're going to do Isabel's.
Is it it's not a Spanish speaking, right?
No.
And what is it, a motion to modify?
Isabel's is let me see.
Quickly. Just have them ready. What is
It's
it?
a motion to modify and reduce arrears to
Okay,
judgment.
we'll wait on that one.
Okay.
Any other ones? I can tell you the ones that on case number,
Elsa had a default, and then that's to be had a default. These are all like radums, Your Honor.
okay, how about the one where they had a proposed agreement, the Calderon case?
I got them to sign off on that one, Your Honor. And the
Okay,
attorney.
we'll read it into the record.
Okay.
All right.
Let me see. So that one was Catherine.
How about the one with Mr. Rodriguez? 13?
That one was that they signed off on that one. That was Elsa's. Yes.
Okay. Then we'll read that one to the record. So they're all defaults. Mr. Garcia Mr. Martinez is back. We'll just
I am
continue
back.
with this one.
Yes.
All right. Mr. Juarez, you may continue with your questioning.
Thank you. Mr. Martinez,
Correct.
Let's see. You heard Ms. Leclerc testify of 15 separate violations where you failed to pay your child support on certain dates.
Correct.
Do you disagree with that testimony?
No, sir. Right now, there's a lot of information with these numbers and the payments not being met, and so I will agree because I agree to the amount that's owed, right? And so my goal moving forward is to get that paid.
Okay, I understand that. So you agree
Yeah.
that you violated the order 15 times, correct?
I mean, I've missed payments. That is correct.
No, that's not my question. I know you missed payments. My question is that you would agree that you violated the order at least 15 times.
That's what it says. Yes, sir.
I'm not asking what it says. I'm asking if you agree with that.
I will agree. Yes, sir.
Okay. Judge, no further questions.
All right. Ms. Poteet, do you have any questions of your client?
Yes, I do, Your Honor.
Okay. You may proceed.
Mr. Martinez, when did you move to San Antonio?
I've lived in San Antonio for the majority of my life.
Okay. Did you used to live anywhere else?
I used to live in Eagle Pass. Correct.
Did you ever have an opportunity to foster a relationship with the child while you were there?
No, ma'am. None whatsoever.
Objection, Your Honor, relevance?
Objection sustained.
And so, Mr. Martinez, you testified earlier that you worked as a real estate agent as your profession, correct?
That is correct.
Were you working as a real estate agent prior to 2020?
Yes.
And did you receive higher commissions during that time in 2019, 2020 time?
Not as much. No, ma'am.
Okay. And why is that?
It's a hard business. It's a hard world. The real estate world is not easy, and it's hard.
Did the COVID-19 pandemic make that even harder on your real estate business?
Yes, it did.
And can you explain how that affected your income and finances in the 2019-2020 time?
I mean, we couldn't work. People were not allowed to go out. People were not allowed to, be in public. And so the pandemic just put a fear in a lot of people that, nobody wanted to be out and about.
And so after your income dropped, what steps did you take to try to continue meeting your obligations?
I mean, I've been trying to make the payments as I could, my wife, she's tried to help me out so that I could pay. And I've just been trying to keep up with the obligation. And so finally I decided that I needed to get this paid, and I wanted to get a full-time job so that I could secure payment for that, so that at least I know that the payment would go out directly for my employer. And then hopefully I can make a career with HEB and retire from there. I'm going to be 50 very soon. And so I'm getting tired, and And so that I figured I'd get me into a career where at least I can retire from or have a decent income because it's been hard. Yes.
And after the real estate business started going down, did you obtain a job elsewhere?
I did. I tried working at Wyndham.
Okay. And while you were working at Wyndham, were you making more consistent payments on your child support?
I was going to start. That is correct. Yes.
I believe the question was, did you
Right.
make more payments, not whether you were going to start?
Yes. There's payments that came out from my paycheck. That is correct. Yes.
Okay. So there are payments ranging, and I'm not going to go through all of them just for the time of the court, but there are payments ranging from the end of 2019 to the beginning of 2020.
All right, and Ms. Poteet, because this is an enforcement, you have to get into the date of those payments. Because on direct questioning, Mr. or Ms. Leclerc testified for each specific month that he had not made payment. So you will have to get into exact date.
Okay. And Your Honor, as an aside, would you let me know if timing is an issue? I just want to make sure I don't.
Well, we're here on this case. We do have other cases, they're defaults. If you all don't have any, to have to be in any other court, we can continue.
I'll continue. So, Mr. Martinez, on June 4th, 2019, you made a payment of $1,077, correct?
That is correct. Yes.
And on July 18th, 2019, you made a payment of $248.77, correct?
That is correct.
What was the date? July what?
July 18th, 2019.
Okay.
And on August 1st, 2019, you made a payment of $248.77.
That is correct.
And on August 15th, 2019, you made a payment of $248.77.
That is correct.
On September 12th, 2019, you made a payment of $232.67.
Yes.
And then in May 18th, 2020, you made a payment of $1,700. Is that correct?
Yes.
Okay. And so, Mr. Martinez, during that time, you looked for other employment, correct?
I did.
And you obtained that employment.
Yes.
And through that employment, you were able to make some payments towards your child support, correct?
Yes.
Did anyone ask you to make those payments?
No, ma'am. I made them voluntarily.
Okay. And so you did your due diligence. Once you realized that you were not making enough money, you wanted to make sure that you sent something for your obligation, correct?
Yes, ma'am.
Okay. And do you currently support a household?
Yes, I do.
You testified earlier that you have a wife and 3 kids. Is that correct?
That is correct.
And in addition to that, you have the child support payments for the child of this suit, correct?
Yeah, that is correct.
Okay. Were there times during the times that you were unable to make those payments in 2019 to the 2020 time, were there times where you had to prioritize food, housing, and utilities for your family?
That is correct. Yes.
And after the job at Wyndham, what did you do for work?
I've been looking for full-time employment with somewhere else, and so I finally got it at HEB.
Okay. How long have you been trying to obtain employment at HEB?
Oh, countless of times. It took me a long time to be able to get in there, but I was able to finally get in.
How many interviews did you have to conduct in order to get this employment?
I submitted employment, interviews. I had to do 2 interviews,
Okay.
but I submitted employment like 15 to 20 different times.
Okay. And have you been applying at other jobs?
I am applying at other jobs, yes.
Okay. So your plan moving forward is to work 2 jobs.
That is correct, yes.
Okay. what is the real estate market like right now?
Horrible.
And
I'm gonna be working a full-time job because I need to make my payments and my bills and I need to work a full-time job.
okay. And so is your plan moving forward that you will be working 2 jobs and your wife will also be assisting you in providing for the household?
That is correct. Yes, ma'am.
Okay. And you are doing this so you can try and pay off your child support as soon as possible?
That is correct. Yes.
Okay. And based on your expenses and based on your income, you by yourself are negative. Is that correct?
That is correct. Yes.
So you cannot sustain your reasonable minimal needs by yourself. Is that correct?
No, it's been hard.
Okay. But you are still acknowledging that you want to make payments towards your child support.
Yes, that is correct.
Have you ever tried to avoid paying your child support?
Never, ma'am. No.
Have you ever evaded service?
No, ma'am. I've always been present.
Have you attended every hearing with the OAG?
Yes, ma'am.
Do you acknowledge that you owe child support?
I do, ma'am. Yes.
What is your long-term plan for paying off this child support debt?
Right now, I feel that the consistency is going to be from my full-time job. And so working full-time, having it come out of my paycheck is the one way I will guarantee that she will be getting her child support. And again, if they hire me full-time where I can get more than 40 hours, then I would like to supplement and pay more towards it so that I can pay it off as soon as possible.
So are you agreeing to a garnishment of wages in order to pay your child support?
That is correct, yes.
And if you obtain a second employment, do you agree for a garnishment of wages from that employer's paychecks?
Yes, that is correct, yes.
So are you making an effort to stabilize your financial situation as it is right now?
I am, yes.
And so what are you asking the court maintain your child support payments at monthly moving forward?
I feel that if I can pay $200 a week, because I get paid weekly from HEB, that'll be able to substantiate or give $800 towards the child support payment and towards the medical. So if $400 could go towards child support and $400 towards the medical, then that'll hopefully I'll be able to pay that off as soon as possible.
So that is roughly about 50% of your paycheck. Is that correct?
That is correct, yes. I
Okay.
want to fulfill this obligation at this point.
Okay. So you are seeking that 50% of your paycheck be garnished so you can pay down the child support and medical support owed.
That is correct, yes.
And is this a realistic and affordable payment plan for you right now?
It's no.
Okay. How?
It's just I mean, I'm not making it, right? And so, but right now, for the sake of paying the child support, I'm gonna sacrifice and then get me the second job that I need so that I can make ends meet and do what I need to do.
So you are only scraping by with your minimal needs, correct?
That is correct.
Okay. If you heard earlier the testimony that Ms. Leclerc was requesting that you be jailed, is that correct?
That is correct, yes.
In your personal knowledge, how realistic is it for you to be able to make child support payments if you are sent to jail?
I won't be able to, no.
Would
It'll
HEB
ruin me. It'll ruin my family.
Would HEB continue your employment if you were sent to jail for 2,700 days?
It will ruin me, yes.
The question is, would HEB continue your employment?
Yes. No, they wouldn't continue my employment. I would be fired.
Okay. So if you were sent to jail for 2,700 days, you would be fired from your job.
That is correct, yes.
And once you get out of jail, would you have a job?
No, ma'am.
So would you still owe that child support?
That is correct, yes.
Okay. So you would still be in debt and with no job and potentially without a family. Is that correct?
Yes.
Okay. So is it your intention to fully comply with the child support orders moving forward?
That is correct. Yes.
Okay. No further questions, Your Honor.
Ms. Urubaso, do you have any questions?
Oh, sorry. No, Your Honor, I do not.
All right, Mr. Juarez, do you have any follow-up questions or cross-examination, I'm sorry, of Mr. Martinez?
Yes, Your Honor. Okay, I know that you testified about it being difficult in 2019 and 2020 because of COVID. My question to you is, you would agree with me that by 2023 and 2024, that we didn't have the same issues with COVID. You would agree with me, right?
No, COVID was, I mean, it finished, correct.
Right. Okay. And you testified that you're barely scraping by with a minimal, right?
That is correct. Yes, sir.
Right. Yet you live in a $350,000 home, right?
Correct. Yes, sir.
Paying $2,300 a month, correct?
Yes.
Yeah, you're barely meeting the minimum. You're barely scraping by, but both you and your wife are driving Mercedes-Benz, correct?
That is correct. Yes, sir.
One that's worth $55,000,
That is correct, sir.
right? And you're paying $1,200
My wife is
out of
paying
that vehicle?
$1,200, correct? Yes.
Right.
Correct. And if
All
I
right.
don't,
And
wife,
and
and
I'm
if I
not
don't-
I'm
okay, go
objection
ahead.
non-responsive.
Okay.
Objection sustained.
Okay. Now the question was asked is if you were ever asked to make payment and you said that you were never asked, and then they asked you, and did you make those payments, and you testified yes. Do you remember that line of questioning?
No, sir, I don't.
Okay. Well, you know that you've been asked to make child support payments from the get-go, from the beginning through a court order, right?
That is correct. Yes, sir.
And you're supposed to be making them every month, regardless of whether you're being brought to court or not, correct?
That is correct. Yes, sir.
Okay, and you're saying that from now, you're going to get 2 jobs,
No, sir,
Correct.
I have one job right now with HEB, correct?
right? But you're looking at getting 2 jobs, correct?
That is correct. Yes, sir.
Okay, so my question to you is, back in 2023, were you absolutely, let me just make sure that I have this. In 2023, the year 2023, from January 2023 to August of 2023, those first 8 months, why weren't you trying to get 2 jobs at that time?
Because I was trying to make it, sir, in the real estate
Right.
business.
Well, and my question to you, at that time, you made 0 payments,
Correct?
right? And then again, from October 1st, 2023,
And I'm not looking
All
at
the
this
way
data.
till-
What data are you looking
to-
at? What information are you looking at?
Objection not responsive. You do understand
Rephrase
that you
your
don't get,
question, Mr. Juarez, rephrase your question.
okay. What I'm trying to get at is that in regards to why are you trying to do more now than what you did all these other times?
Sir,
That's what
because
I'm
what
trying to
I was
figure out.
doing before was not working, and I had this bill that I needed to pay.
Right,
And
and you
so
would
if
agree
I
with me
don't
that
pay
now
this
you're,
bill, if I don't pay
Right.
this bill, I do not
What
want to go to
happens?
jail.
right? So jail is
I
the
have a
motivating
family that I
factor.
need to try to support.
Let's
and
not
my-
talk
Right,
over
would-
each other. Mr.
sorry.
Martinez,
Yes,
hold
ma'am.
on until he asks you the question.
Right,
Yes,
And
So
ma'am.
you
Mr.
would,
Juarez, let him respond.
right, so you would agree with me that the greatest motivating factor for you right now, what has you up, even almost in tears, Mr. Martinez, is this thing about you going to jail, right?
No, sir, and I'm going to rephrase to you what you just said. What has me in fear is my wife and my kids. I don't want to lose my family because I go to jail. Because I
Right,
have
right.
the opportunity to work at HEB right now so that I can make this right. And I
Right, and
want the
so,
opportunity to make it
for-
right.
But for that, you wouldn't be in fear,
My
right?
family is what has me motivated, sir.
Right, exactly.
My wife and my three
exactly.
kids.
Asked and answered. Do you have another question, Mr. Juarez?
Okay, Judge, no, I don't have any further questions, Judge.
Ms. Poteet,
Okay.
any follow-up questions of Mr. Martinez?
Yes, I do, Your Honor.
Oh,
may
I'm sorry. Okay. I apologize, Judge.
Mr.
That's okay.
Martinez, isn't it true that on September 19, 2023, you made a payment of $6,468.10?
That is correct. Yes, ma'am.
Okay, so in 2023, you did make a payment. It was a substantial payment.
That is correct. Yes, ma'am.
Okay. During this time, were you trying to lift your real estate business up?
I've been trying.
Because you would essentially be making more money doing real estate than working hourly at Wyndham. Is that correct?
That is correct. Yes, ma'am.
Okay. And isn't it true that in June 4th, 2024, you made a payment of $4,000?
That is correct, ma'am.
Okay. And isn't it true that in October 3rd, 2024, you made a payment of $1,000?
That is correct, ma'am. Yes.
Okay. And these payments were within your means at the time?
With my wife and myself, yes. Mainly my wife, correct.
Okay. So you and your wife were helping each other to meet this obligation as well as continue your household?
That is correct, yes.
Okay. Do you have plans to downsize your assets in accordance with your new lifestyle and income?
The way things are going right now, yes, that might be something that we're going to do. And again, for the record, right now, my situation at home with my wife is not looking the best because of the situations that we're in.
So this has caused a rift between in your marriage. Is that correct? Okay. And is that the driving force for you wanting to get this debt paid? Do you need a minute?
Ms. Urubaso, while he's taking a moment, can you share the financial statement again on the screen, please?
I will, Your Honor. Let me do that right now.
And now, Mr. Martinez, you never paid her any monies directly. Or any monies that you sent was through the disbursement unit, correct? Okay. Let me just take a look at it one more time.
Yes. This is yes and yes. Okay.
Right. And go back, you all are going back as of August 31st, 2025. So start there for me.
Okay, Your Honor. Let me scroll down here. Oh my.
Again, it's not going to let you.
Yeah, it's because I have to upload it in a different manner. Sorry, Your Honor.
That's okay.
Uh-oh. Let me stop sharing. Okay, let's try to open this another way. There we go. Okay. Open in browser.
I'm sorry about that, Judge.
That's okay. That's okay. I needed to see the financial statement anyway. And while she's doing that, Mr. Martinez,
Yes, ma'am.
you stated that you started working for HEB about 3 weeks ago.
Yes, ma'am.
And your real estate license, you still have it, right?
It's probably going to get put on hold.
I just need a yes or no.
Yes, correct.
Okay. All right. And do you recall if in 2024, did you sell any homes? And I don't need an exact amount, but did you at least sell one home in 2024?
Yes, ma'am. Correct.
Okay. How about two homes in 2024?
Correct.
All right. Do you recall, only if you recall and you remember, if it would have been more than 5 homes in 2024?
I don't recall, ma'am. No.
Okay. All right, Ms. Urubaso, take it down to August the 31st. There we are. Okay, I see the payments he did make. Scroll up. So if you, all these payments that were made, for example, in 2000, June, May, June, July, and August, Mr. Martinez, you were making them directly, or were they wage withholding?
No, they were going directly to the child
No,
support.
but were you paying them voluntarily, or were
I
they
was
taking
paying
them
them
from your
voluntarily.
paycheck?
Yes. Yes,
Okay.
correct.
All right, so I see here, I'll stop right there, Ms. Urubaso. I see here that in May, the payments came in. March and April, January, February, March, and April of 2024, there were no payments. November and December of 2024, there were none. I do see that large payment in October. All right.
You'd like me to scroll up, Your Honor?
Yeah, to 2023, I think they asked him those questions.
Two 2024 here.
There's a payment in June that you scrolled by that I
Yeah, I got, hold on, of 2024. That was a payment of 3,849. So,
and then medical support was 151.
right, so from July, go down, Ms. Urubaso. July, there was no payment. Stop right there. August and September, there were none. But there was one of $1,000 in October. And then November and December of 2024, there was none. There was, and then January, February, and March of 2025, but then he picked them up again in May of 2025. He was making payments. All right, and then go to 2023, because Mr. Juarez questioned him about 2023. So December, well, stop right there. It's fair to say he made a payment in September. So October, November, and December of 2023, which is what he was questioned on. Okay. And then June through August. All right. All right. Thank you, Ms. Urubaso. I know, Mr. Juarez, you came out with a different amount, but it wasn't by much. You all stipulated to the child support's arrears of $35,229.27, with medical of $24,227.47. Your total that you questioned her on, Mr. Juarez, was $59,527 as it was set out in your motion. It's a little bit different, but I'm assuming your $59,000 would have included just child support or medical support.
No, Judge, it would have included both, but I don't know if the difference is that he made a payment like 2 days ago. It's like a $300 difference.
Because your motion alleges that in July of 2025, and you asked her about it, if I'm not mistaken, you were alleged, her testimony was
59,527 with 37 cents. Yeah. With 37, and that's what my exhibit shows, Judge.
But is that just child support?
No, that's both
okay.
Medical
Didn't question on her. You just went down the child support payments, but when you look at that amount.
Yes, Your Honor. That's correct.
All right. And Mr. Martinez, in your license, you still had your license. I questioned you about 2020. You have it now. And you had already given testimony about houses that you sold in this year, 2025. You testified you at least sold 2 houses in 2024. How about in 2023? You did have your real estate license in 2023? Do you remember approximately how many houses you sold?
I don't recall, Judge.
Okay. Would it have been more than 5?
Maybe around 5.
Okay, you're just not sure of the exact number.
That is correct, Judge.
All right. Ms. Poteet, do you have any, I interrupted you because you needed a moment, but do you, you may continue.
It's okay, Judge. Thank you. So, we've already discussed, what your motivation is, right?
Yes, ma'am.
But just moving forward, you do have plans to downsize some of your assets, correct?
That is correct. Yes, ma'am.
And that is based on what your new income is, correct?
That is correct. Yes, ma'am.
Okay. Is it fair to say that your lifestyle prior to 2019, when you had a more booming real estate business, is completely different from your lifestyle now?
I mean, it's different. Yes.
Okay. And the home, did you purchase that with your wife?
With my wife, correct.
So that is a community asset?
Yes, that is correct.
Was that purchased in the last year?
Yes, we've had it for 2 years, I believe.
Okay. And so who is the financial backbone of your family right now?
My wife.
And what has she been the financial backbone of your family since 2019?
No, since 2021, 2020.
So 2020 to 2021 was when there was a shift.
That is correct. Yes.
Okay. So you were unable to meet the minimum reasonable needs of you and your family around that time, correct?
That is correct. I'm behind on my mortgages and so yes.
What was the time frame, Ms. Poteet?
2020, 2021.
Okay, got it.
You're behind on your mortgage. How behind are you?
6 months, 5
Okay.
months.
Okay. Have you received notices?
It's owner finance through the owner, and so he's working with us so that we can kind of keep the house.
Okay, so you are working with the lender to modify your payments so it's something that you can afford.
With the owner finance, correct. He's an owner. It's a man that owns a house, and so
So he's financing.
that is correct. Yes.
Okay, so this isn't something that you had to go out and get a bank to obtain a
No.
loan or anything.
Correct.
Okay, so he's workable with you.
He is. Yes.
So that is why you're able to pay at least 50% of your paycheck towards
That is
child.
correct. Yes.
So you're doing everything you can on your end to
Yes, ma'am.
reduce your expenses.
Yes.
Okay. Do you fear that you might lose your home if you continue to be to owe money on that mortgage?
That is correct.
Okay. Do you have some time before that happens?
I'm working with him. Yes, that is correct.
Okay. And very briefly, just because I forgot to bring this up earlier, but very briefly, did you have an interaction with Miss Leclerc since 2019?
I did. One interaction in particular, correct.
Okay, when did that interaction occur?
Maybe about 2-3 years ago, I was at La Cantera Mall with my wife, and we were at a shop outside one of those kiosks, and she came up to me and my wife, and she started yelling at us,
Objection, Your Honor, relevance.
telling me that I needed to pay child
Hold on,
support.
Mr. Martinez, relevancy, Ms. Poteet,
Your Honor, I just
towards
wanted
the
to
enforcement.
Yes, I just wanted to circle back. I should have laid a better foundation, but I wanted to circle back to retaliation when I was questioning Ms. Leclerc.
You could, but I don't think that it's relevant because I think on an enforcement, you just need an order with the obligated to pay. And in this case, it was through the disbursement unit. If it was retaliation, I mean, I don't see it. So, objection sustained.
That's okay, Your Honor. Okay, and just to wrap it all up, Mr. Martinez, at this time, you are asking the court so you can pay $800 monthly towards your child support medical support arrears,
Yes,
and that is through garnishment of wages, correct?
right. Yes,
And you would like once you obtain that second job that you're applying for, you would like garnishment of wages of that job as well.
That is correct, yes.
You will maintain the Office of Attorney General appraised of that job.
That is correct, yes.
No further questions, Your Honor.
All right, Mr. Martinez, the GLE 350 Mercedes, I know you said that your wife drives it and she pays for it, I believe, but whose name is it under?
They're under my wife's names.
Okay, but you purchased it during the marriage, correct?
That is correct, yes.
All right, how about the C300 Mercedes? Whose name is that under?
That's hers. That was hers.
Okay, and you also purchased it during the marriage?
No,
Or she had it before?
she a little bit before, correct.
Okay, how about the Honda Civic?
That is my son's, my 21-year-old, my son.
It's his car.
That is his car.
All right. And it's under his name.
No, that one was under my name, but I went through one of those high finance banks.
Okay.
And so he's
So
the
it's
one.
under your name, but it's his vehicle. He
That
uses
is
it.
correct. Yes, Judge.
All right. Do you have any follow-up questions, Mr. Juarez?
Just briefly, last year, how much did you make, Mr. Martinez?
I don't recall, sir.
More or less, just give me a ballpark figure.
I don't recall.
Yeah, just
Did you
just
file
a
an income
ballpark.
tax return, Mr. Martinez?
No, ma'am.
You haven't filed it for
No, ma'am.
2020? No?
I haven't filed my taxes. No, ma'am.
Did you make more than $10,000?
Maybe. I don't recall. Yes.
Are you just not telling the truth, Mr. Martinez?
Sir, I
Objection,
swear
Your
under
Honor.
oath, sir.
Objection sustained.
Okay,
It's
I swear
argument.
under oath.
No further questions, Judge.
All right. Based on the testimony that the court has received, the court, first of all, is granting the child
Oh, Judge,
support.
I'm sorry, Judge. I apologize, Judge. I still had one more witness,
Who is the
and it
other
was
witness?
myself, because under these types of enforcement, because of the large amount that's owed, I'm entitled to attorney's fees, Judge.
Can we bring that up in a little bit?
Yes, yes,
uh,
that's fine. That's fine.
All right. Based on the testimony that the court has received, and I am looking at your court file, Mr. Martinez, this is your first time on an enforcement. You don't have any prior enforcement, so that's good news. But the court is finding that the arrears that are owed as of August the 31st is $35,229.27 in child support, $24,227.47 in medical support. I will give you a payment plan. The court is finding that you have not been following the child support court order as obligated. So the court is sentencing you to 6 months in the county jail. But we're going to defer it. The court finds that you did not pay for November the 1st, December the 1st of 2023, January, February, and March of 2024. I know there was plenty of evidence about these 2,700 days and the 15 violations at 180 days, but the family code states I can only incarcerate you for up to 6 months, not more. So the court is sentencing you to 6 months in the county jail, but we're going to defer it. What all that means is you're going to be placed on probation, Mr. Martinez, and I'm going to give you a payment plan. And I will explain that to you in a little bit. The court further finds that you also did not pay the medical support. So for those months, you did not pay $628 in child support plus the medical support. There were other payments that you did pay, as your attorney brought out, but they were not those 5 specific months, okay? The court is going to give you the payment plan, $400 towards the child support arrears and $400 towards the medical. That's what you're going to pay. The court is ordering you to pay a lump sum towards the child support arrears of $5,000 and $3,000 towards the medical arrears. So that's a total of an $8,000 payment. The court finds the child has emancipated, so he's already over 18, and the statute of limitations is obviously at issue here. What we're going to do is we're going to have you come back on December to give you time to save that up, Mr. Martinez, the lump sum. So your payments of 400 towards the past due child support and 400 on the medical support arrears, that is going to be starting October, November, and then we'll come on December the 16th, 2025 for the lump sum. Okay? The lump sum of 8,000. That gives you time to save it up.
Yes, Judge.
If either side wishes to appeal the decision, you can. You've got 3 business days. 3 business days from the date that I signed it. However, I'll let your attorney, Ms. Poteet, talk to you about that because these are not final orders yet, but the family code sets what you can do on an enforcement. I'm going to give you time to bring in the lump sum. Now, here's the issue, Mr. Martinez, but I'm going to get the assistance of your attorney. Because we're doing this virtual, you're waiving your right to an in-person hearing. That lump sum, you're going to have to send at least a week before. And Ms. Poteet, if you could just help him get the number of the money order, get everything so that we can track that payment. Because hopefully if he sends it through the disbursement unit, or the other thing, as an officer of the court, Ms. Poteet, because my experience is when we grant lump sums, the non-custodial parent has to come up with it and is usually waiting, to the very last minute to come up with lump sums. As an officer of the court, and I'm sure Mr. Juarez will agree with me, if he gets the money ordered to you on the date of the hearing date, to where you can confirm with me that he left it with you, then obviously we can do it that way. Mr. Juarez, if you'll allow me to do it that way.
Yes, Your Honor. I just want to make sure that I understand this correctly. By December 16th, he will have had to have paid $8,000 plus $800 on October?
No, the court is placing him on a deferred commitment. I am sentencing him to 6 months in the county jail today, but we're going to defer it. We're coming back on December the 16th. In order for him to stay out of jail, he has to pay $800 towards those arrears for the month of October, November, and then on December the 16th is when he gets to his attorney the $8,000.
Okay, and so so I just want to make sure we're both on the same page, Judge. So aside from the $8,000, if he fails to make aside from that on October payment of $800 or November payment of $800, then he will be in contempt, correct?
No, he is being found in contempt today.
Okay.
What will happen if he doesn't, when we're here on the 16th, so and your attorney will explain to you, Mr. Martinez, so what you have to do is October the 1st or shortly after October the 1st, you send in $800 through the disbursement unit. And then November 1st, another $800 towards the disbursement unit. So when we come in December, they're going to report to me whether you made it for October and November. If you sent in those 2 payments through the disbursement unit and you bring the lump sum of $8,000, you will not go to jail. We close the case. And Ms. Leclerc, I can't add the December payments to that because since we're coming back on the 16th, he still has 2 more weeks to obviously send the December's payment. Okay? And what we can do, Mr. Juarez, I told you we could bring up the attorney's fees. The attorney's fees are mandatory if you file a motion. However, we can bring your attorney's fees up in December, so that allows Ms. Poteet to review your invoices. So if you could file your fees in way of an invoice, file them, send her copies of it, so that if we need to have a hearing on how much attorney's fees, she'll be able to question you on it after she receives the invoice. So we'll just take that up in December. Is that okay, Ms. Poteet?
Yes, just clarification. He's going to need to file a motion and then provide those invoices over to me.
Yes.
Not a motion, Judge. I already filed.
You could say that they're not called for. whatever you want to say. We'll have a hearing on the attorney's fees, Mr. Juarez, okay?
Judge, I don't need to file a motion because it's already in my motion.
You can, I don't know how, if you just, I don't know if you just want to file invoices just like
Oh,
that.
yes. Yes, Your Honor, I
Because
will.
Mr. Vielma needs to track it, so what you could do is,
Yes.
I agree with her, file the motion and attach the invoices,
Yes, Your Honor. Okay.
all right?
Yes, Your Honor.
And we will be back here on December the 16th. Now, Mr. Martinez and your attorney's gonna help me with this. Make sure you show up. In
December
addition to
16th.
giving her the money, make sure you show up. If you fail to show up on December the 16th, then I can issue an order out for your arrest. So if you're having trouble logging on, get to her office. I don't know if you all are in the same location, San Antonio, but make sure you show up, Mr. Martinez, okay?
Yes, ma'am. Yes, Judge.
All right, if either one of you wishes to appeal it, you can. You've got 3 business days from the date that I signed the order. You filed something, and that's business days. That doesn't include weekends. But both of you have attorneys, so you all can have them explain that to you. But I just have to give you the notice that you have that right on the record. So we will see everybody on December 16th.
Judge, I just want to make sure that I understand this correctly. So he's tentatively as of right now, he is placed on probation for 3 months from now to December?
It's a deferred. It's a deferred until he's being sentenced to 6 months in the county jail, but we're going to defer the actual incarceration until December the 16th. So you will, and I'm glad you're bringing it up, Mr. Juarez, you'll have to prepare the order.
It's a deferred, but it's only until December 16th.
So
Okay.
like a deferred adjudication.
Yes. And so the language has to be on the order that I'm finding him in contempt. I'm sending him to jail for 6 months, but we're going to.
Is it for each
It's a
violation or 6 months in total?
It's a compliance. He's going to come in on December the 16th for compliance to see if he has met the conditions of his probation, which are
Right.
$800 for October, $800 for November, and the lump sum.
And he's being held in contempt for 6 months for each violation to run
180
together
days.
or total?
And you have to set out the months that the court found he didn't pay, which was November and December of 2023 and January through March of 2024. And so you have to set out that language, those months in connection with the 180 days.
Right, and it's for every violation, is it 180 days to run together or is it all together?
I can't send him to jail for more than 6 months. It is set out in the family code under the enforcement section,
Yes, Your Honor.
and it does tell you what the order has to say.
Okay.
Okay. And
All right,
if you
Judge.
file it, I will prepare it. Know that it has to be done before we come in December, obviously.
Yes, Your Honor.
All right.
Your
You
Honor,
all-
on that, Your Honor, just for the Office of the Attorney General's clarification, we are also
You're going to
taking a
prepare the
judgment.
confirmation of arrears,
Okay,
Ms. Urubaso.
thank you.
And what cost to be assessed to the obligor on the arrears, because he does owe the money, okay?
Yes, Your Honor. Okay, thank you for the
There being nothing-
clarification.
Yeah, there being nothing further, you all are excused.
Thank you.
Mhm.
Thank you.
Thank you.